Chapter 4, Housing. In this chapter, we're going to identify protections of the federal housing laws, including enforcement. We're going to describe protections of the New Jersey Law Against Discrimination, the LAD for short, including state regulations on rentals. We're going to discuss the implications of fair housing laws for the brokers and salespeople. So, equal housing, equal opportunity in housing. Why do we have equal opportunity in housing? So everybody can have a place to live. That's why. So, federal, state, and local laws about human rights and fair housing affects rentals and sales alike, and every phase of the real estate transaction from listing to close. Failure to comply with fair housing practice is not only grounds for the loss of your license, but it's also an unlawful act. And here's a little tip for you. Whenever two laws cover the same topic, the more restrictive rule will always prevail. And that applies to everything, not just discrimination, anti-discriminatory laws or fair housing, it deals with everything, even zoning laws. If you got two laws that cover the same topic, you got to follow the more restrictive rule, always. Just a general rule in life. So, why do we have fair housing laws? Well, so everyone can have equal rights for an opportunity to have a place to own, to live, to own or rent, to be able to own personal property like the clothes on your back. So everyone can have an equal rights. Opportunity. We're not all guaranteed the same outcome in life. I notice that this is a going trend, especially with younger crowds these days. Everybody expects to have the same outcome. And then they fill in the excuse why. You are not entitled to squat. The only thing you're entitled to is the opportunity to try, to work hard and get the things that you want. You're not entitled to squat. You are entitled to work hard and try to earn those things and be given that opportunity. Those are the rights that you are entitled to. You are definitely entitled to those rights. You're not entitled to the outcome, though. And this is probably one of the big problems with a lot of society today is people think that they're entitled to something. They got that entitlement about them. You have to work hard to get stuff. Okay, so everyone is entitled to have equal rights for the opportunity. And violating these laws is a criminal act when we don't give them those rights. So it all started way back with the Civil Rights Act of 1866. Who was president back then in 1866, where there was a big thing that had to deal with rights and slavery and all that stuff? I'm not asking too much in specifics. Yeah, Lincoln. Yeah, Lincoln. Lincoln freed the slaves, the Emancipation Proclamation, and all that jazz, right? Come on, we all know the basics. I'm not asking you to know all the details behind the history, just some of the basic framework there, right? So the efforts of the federal government guarantee equal housing opportunities to all U.S. citizens. That began with the passage of the Civil Rights Act of 1866. So all U.S. citizens have the equal right to housing opportunities, according to the Civil Rights Act of 1866. This became an outcome to the 14th Amendment of the United States Constitution, which is the law of the land, that prohibits any type of discrimination based on race and color. Says that all U.S. citizens in the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey both real and personal property. Because what did Lincoln do back then? He freed the slaves. He said that everybody has a right to own real estate, to have a place to live or rent. And you're entitled to own your own clothes on your back, right? So you're allowed to have property. So this law, the Civil Rights Act of 1866, covers what kind of property? Both real and personal. When I say real, I'm talking about real estate. And that covers everything, commercial, residential, real, and personal property. All property. There's only two kinds of property on this planet. It's either personal or it's real estate, right? So this law covers all property. And who is the protected class in it? Race and color. Now, because of the reference to white citizens, this law has been widely interpreted to prohibit discrimination based on race and or color. So on exams, who do you think that it's going to pertain to? Race and or color. Even though much later, they also added some additional protected classes to this law. But before we get to that, in 1968, there was a Supreme Court decision about Jones versus the Alfred H. Mayer Company that affirmed the Civil Rights Act of 1866 that prohibits all racial discrimination in private and public in the sale of rental property, in the sale and rental of property. When it comes to race, there's never an exception to the law. Because we're going to learn that in 1968, we had that whole civil rights movement. You guys ever hear that? That big civil rights movement in 1968? So with all of those laws that were passed in 1968, they also carved out some exceptions for certain situations. But that does not give you the green light to be able to discriminate. That's not why they carved out exceptions. We're going to learn about those exceptions for the 1968 law. So this person, Alfred H. Mayer Company, figured that, hey, you know what? I could discriminate against a person of color because the 1968 law carved out certain exceptions. But remember, I told you, when two laws cover the same topic, the more restrictive rule will always prevail. So you always fall back on the law that says when it comes to race and color, there are no exceptions. So even though one law had exceptions to it for a certain reason, it falls back on the other that says that there isn't any. So when it comes to race and color, you can never discriminate. So we got the Civil Rights Act of 1866. It's a part of the 14th Amendment of the United States Constitution, granting equal rights to all citizens for ownership of both real and personal property. That's all property. So when it comes to race, there's no exceptions to this federal law. All types of property are covered, all real estate, residential and commercial, including unimproved land and personal property, like the clothes on your back, in your car, your personal belongings, your jewelry, etc. The protected class is race and color. Later on, in 1987, the 1866 law was amended to also include ethnicity and religious groups, ethnic and religious groups as well. So, who enforces the Civil Rights Act of 1866 when it comes to real estate? HUD. HUD is the Department of Housing and Urban Development. And violations under the Civil Rights Act of 1866 must be heard in federal court, and the statute of limitations is determined by state law. Federal court has no monetary caps on their awards or settlements. So, let's learn about the next law, the Federal Fair Housing Act of 1968. Keyword in there, housing. What kind of real estate are we talking about when we have the word house in it? Talking about residential or commercial? Housing. A little hint right there in the title. Guys, gals.
Residential.
Residential, right? Residential is housing, right? So the law, the Federal Housing Act of 1968 covers what kind of real estate? residential. It does not deal with commercial, only residential real estate. So the Federal Fair Housing Act of 1968 is contained in Title 8 of the Civil Rights Act of 1968. Oh my God, my mind is spinning out all these laws. No, 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 no. Let me simplify this. Let me dumb it down a little bit. We had that whole Civil Rights Act movement in 1968 where they passed all kinds of laws. You know, you can't require people to sit on the back of the bus and have separate bathrooms in schools and segregation and all that stuff. So that was the whole body of the laws of the Civil Rights Act of 1968. But there was a section of it that dealt with housing. That section was Title 8. Now, Title 8 was also given a name, the Federal Fair Housing Act of 1968. So the Federal Fair Housing Act of 1968 is Title 8, okay, of the Civil Rights Act of 1968. Better to understand? Does that make it any easier? So it prohibits all discrimination on the basis of race, color, religion, national origin, including the origin of your ancestors, or sex when selling or leasing residential property. Let me see. 1, 2, 3, 4, 5. That's only 5 of the protected classes. Under federal law, there are 7 protected classes. We'll get into them. They added them later. This law impacts direct providers of housing, including landlords, real estate companies, as well as municipalities, lending institutions, homeowners insurance companies, etc. So, the Federal Fair Housing Act of 1968 has a section called Title 8, which is known as the Federal Fair Housing Act of 1968, and it does have some exceptions to the law. It covers residential property, including vacant land meant for residential purposes. The protected classes under this law are race, color, religion, national origin. In 1974, they added sex and people with disabilities, including AIDS, and familial status. That's the 7th one. So there are 7 protected classes under the law, under federal law: race, color, religion, national origin, sex, disability, and familial status. That means people with families, with children. That includes adopted children or foster children. Alcoholics and persons in drug treatment programs are considered a protected class. However, current drug abusers and people who pose a threat to the health and safety of others are not. Except under New Jersey law. New Jersey law, we're going to get into that one. Wow. We like our criminals here. It is so weird what goes on in politics in recent years. Politicians have lost their freaking minds. And even worse, the people who support them have as well. You treat it like it's your favorite football team or baseball team that, hey, I'm a diehard even when they're doing bad. You know, politicians, when they do bad, they're freaking morons. All right. Yeah, they stick up for the criminals over the law-abiding citizens. All right. That's kind of stupid. So current drug abusers and people who pose a threat to the health and safety of others are not a protected class. Although New Jersey makes them one. Enforcement is done by HUD. So the Department of Housing and Urban Development, you have 1 year to file a complaint if you've been discriminated against using under any of these protected classes. Or if you make a federal case out of it, you got 2 years to hear it in federal court. And then there's no monetary caps on the awards or settlements because federal court doesn't have them. So the Federal Fair Housing Act of 1968, let's do the highlights and let's add in these terms that I added here. So on the 1, 2, 3, 4, fifth bullet point on page 68, let's highlight the protected classes and add in their sex as a protected class. And then we're also going to write blockbusting / panic peddling right after that bullet point, because that bullet point is describing what a practice known as blockbusting and panic peddling is. And then after the next bullet point, let's write the word redlining in there. That's one word, redlining.
Where?
Good?
Where?
I'm sorry, what was that? You said you're good? Or
What did you say? To write?
so redlining goes under the next one. See this?
Okay.
It's easy to pass over. It kind of looks like it could be there still, but I wrote that. I typed that. Redlining practice we're going to go over. Okay. So everybody got these highlights in these notes? All right, I'm going to change the slide. If you need longer, let me know. All right, so this is everything that was on the previous slide. I just kind of tweaked the wording of it a little bit. If you want to follow along in the book while I read these bullet points, that'd be fine. You can see the modifications I made. Some of them, they're just slight. Some of them, they're a little bit more. So Civil Rights Act covers dwellings and apartments as well as vacant land acquired for the construction of residential buildings and prohibits the following discriminatory acts: refusing to sell, rent, or negotiate with any person or otherwise making a dwelling unavailable to any person as a means of discrimination. Changing terms, conditions, or services for different people as a means of discrimination. Practicing discrimination through any statement or advertisement that restricts the sale or rental of residential property. Representing to any person as a means of discrimination that a dwelling is not available for sale or rent, when in fact it is. Making a profit by inducing owners of housing to sell or rent because of the prospective entry of persons of a protected class into the neighborhood. Those protected classes would be race, color, religion, national origin, sex, disability, or familial status. And we call that blockbusting or panic peddling, because you get people that are trying to stop the block by using discrimination as the tool to fearmonger, telling stories to the property owners to try to scare them into selling. Some of them went as far as in the neighborhoods, they would go to the neighborhoods, they'd go knocking on people's doors and saying, hey, did you hear who's moving to the neighborhood? We've got all of these, and fill in the minority, is moving to the neighborhood, and they're going to drive down your property values and whatever. They would come up with some kind of a panic, fear-mongering story to scare you, the homeowner, into selling their property. And then, of course, they'd act like the hero. I'm willing to step in and buy that property from you. Of course, I'm not going to pay you top dollar, because property values are going down and all. But I'll give you a good deal, And then they turn around and sell the property to the very minority that they were fear-mongering about at a marked up price. That's what blockbusting and panic peddling is. And so you don't really see these practices too much anymore, at least when it comes to race. You may still see it when it comes to certain things like maybe religion or disability. Here, let me give you an example. Do you hear what they're doing with the property next door? They're turning it into one of those properties for the mentally disabled. You're going to have all these crazies in your neighborhood now walking around and doing all kinds of crazy stuff. Oh my God, it's going to turn into a madhouse around here. And they're trying to scare people. Or let's see what else. They're going to turn it into a halfway house for battered shelter for women. This is going to be they're going to bring around their violent exes and all this, and it's going to become a dangerous area. Or what else? What other kind of stories can they make up? I don't even know. There's so many different stories that they can come up with. Disability. They're going to turn it into a rehab next door. You're going to have all these drug addicts with needles and stuff all over the ground, because they never cold turkey. So you're going to have, they're going to be bringing a lot of drug addicts into the neighborhood now and drive your property values down. That's what they're going to do next door. Okay. This is all still blockbusting and panic peddling. It's not just about race. It's about race, color, religion, national origin, sex, disability, familial status. Using any of those protected classes, coming up with a fear-mongering story to spread panic. You're peddling, you're selling panic to try to bust up the block. Okay, so who's it discriminating against? Who is blockbusting discriminating against? The homeowner. It's using discrimination as the tool to spread fear to try to scare them into selling. Altering terms or conditions for a home loan or insurance policy to any person who wishes to purchase or repair a dwelling or otherwise deny such a loan as a means of discrimination, even though they could afford it. That's called redlining. Think about accounting for a second. Accountants. When do they use red ink? When something ain't right, when something ain't good, when they don't like something, right? So think of that. Even though that's not where the term redlining comes from, I will show you where the term redlining comes from. But that's a good way to remember that redlining has to deal with the finances, insurance or home loans. Refusing to give somebody an insurance policy or a home loan as a means of discrimination. They put a red line through your application. Think of it that way. This way you try to associate the red ink with the finances, right? Denying people membership or limiting their participation in a multiple listing service, real estate brokers organization, or other facility related to the sale or rental of dwellings as a means of discrimination. Yeah. That's like me trying to join the African American Association of Realtors or Hispanic Association or Women's Council. I don't fall into any of those categories, but yet I cannot be denied membership if I wanted to join any of them, because that would be discrimination. So some exceptions to the federal law, to the Fair Housing Act of 1968 include the following, but never on the basis of race or color, because it always falls back on the Civil Rights Act of 1866, where there are no exceptions when it comes to color, right? The sale or rental of a single-family home is exempt when the home is owned by an individual who doesn't own more than three such homes at one time, and a broker or salesperson or agent is not used, because under no circumstances are we ever allowed to discriminate. And B, discriminatory advertising was not used. If the owner is not living in the dwelling at the time of the transaction or was not the most recent occupant, only one such sale of an individual is exempt from the law within any 24-month period. The rental of rooms or units is exempt in an owner-occupied 1 to 4 family dwelling. Dwelling units owned by religious organizations, not religious people, but religious organizations, may be restricted to people of the same religion if membership in that organization is not restricted on the basis of race, color, national origin, disability, or familial status. A private club that's not open to the public may restrict the rental of its occupancy of lodgings that it owns to its members, as long as those lodgings are not operated commercially. So those are the exemptions to the Federal Fair Housing Act. In 1968, the Act was also amended several times to add additional protections. 1988, mental and physical disability, including those with AIDS, was added. 1988, they also added familial status. That's family members under the age of 18, including foster children, adopted children. 1995, familial status also covers things today like breastfeeding and stuff like that, having children under the age of 18. 1995, Housing for Older Persons Act, HOPA, contains a limited exemption from the familial status. Basically, it's housing for older persons, senior housing in 55 plus communities. It's not considered discrimination under the familial status because you don't allow children under the age of 18 to live there, because the housing is meant to be for seniors. Okay? So there's an exemption for the law for that reason. Now, in 1974, they passed a law called ECOA, the Equal Credit Opportunity Act. If anybody's familiar with this, it has to deal with women's rights. Women were discriminated against. It was only about women. All right. Now, of course, here when they give the explanation, they throw in all the protected classes are covered under this. But this law was created specifically for women, because the little lady came in to buy a car or to buy a house, and the guy dismissed her there and said, "Why don't you come back with your husband and we could discuss the money matters?" Okay, little lady. The women were dismissed. You can't possibly be buying a house all on your own. Why don't you send your husband down and we could discuss these matters? You're treated like a second-class citizen, or kind of dismissed. So in 1974, the Federal Equal Credit Opportunity Act was passed. It made it illegal for creditors to discriminate against applicants because they were women. Okay. Now, of course, here they're throwing in all the different protected classes. But even here, you can even look at the end of it. They say, well, women thus had access to more housing opportunities after this. Yeah, because this law was specifically for women. But they add all the protected classes to it now as well. It basically says that if anybody ever applies for credit for something, to buy a car, to buy a house, to get a credit card, if you're ever denied for a credit card, for car financing, mortgage financing, anything, under ECOA, the creditor is required by law to notify you within a certain time frame the specific reason why you were denied. Okay, they want to make sure that it was not because you were a woman, because that's a protected class, or any of the other protected classes. Now, alcoholics and persons in treatment programs are considered a protected class under the disability, but current users of illegal controlled substances are not. I guess unless we're talking about illegal substances that are being allowed in certain states, which gets kind of weird because under federal law, they're illegal. Under state law, they may not be, like weed. In New Jersey, it's legal for recreational use. Some states like New York, they got stations that they set up where people can shoot up heroin, for crying out loud. It's crazy. So it kind of like messes with these laws a little bit. What about those residents that live right outside or next door to that place where they got these centers set up where people can shoot up their drugs? Well, we know what happens because we watch the news. Let's not be ignorant about it. There's needles on the ground. There's all kinds of whacked out, drugged up people in the neighborhood now. And that does end up posing a threat to the health and safety of the people that live in the neighborhood. So other persons who are not considered disabled include persons convicted for illegal manufacture or distribution of a controlled substance, sex offenders, and juvenile offenders. So they don't fall under the protection of disability. However, New Jersey law, they do fall under the protection of people of color and their race. Because remember, You can't do criminal background checks on people, I told you several times already, because, criminal justice system is inherently racist because there's more black people in prison than there are white people. Therefore, the criminal justice system, there's a leap that was made there that makes that's what makes the criminal justice system racist, disregarding the fact of whether anybody actually committed the crimes or not. And therefore, that makes them a protected class, which we're going to be getting into that when we get into the New Jersey LAD. So familial status. You cannot discriminate against those with families, adopted or foster children, particularly with children under the age of 18, including pregnant women. I had somebody to try to discriminate against a client of mine because she was pregnant. It was interesting. I'll tell you that story when we get to reading the LAD. There are some exceptions to the familial status protected class in housing that's meant for older persons, the 55 plus community and senior housing. It is not considered discrimination to not allow people there with children to move in there because it's meant to be for older persons. So senior housing, what is that? It is housing meant strictly for people 62 and older. However, the facility has to post at all the entrances there that they comply with HUD's rules that the housing is meant to be strictly for people 62 and older. Now, what's a 55 plus community? That's for communities where at least 80% of the occupants have at least, of the units have at least one person that's 55 or older living there. And the community has to post that it adheres to policies and they intend to use it for housing for older persons. So, can you buy a condo in a 55 in a senior housing complex? Can you buy a unit in a senior housing complex if you're 30 years old?
Yeah. Because there's only 80%, no?
No, I said senior housing.
Senior housing.
Yeah, with 62 and older. Can you buy a unit in a senior housing complex if you're 30 years old?
No.
Do you believe it should be that way?
No, let's keep it that way. It's better. I don't think that many 30-year-olds want to hang out with older people.
And what's the purpose of having a senior housing community after all, right? To keep the costs down, right? Maybe to give tax breaks and such to the seniors, right? So it wouldn't make sense to allow 30-year-olds to buy in a senior housing community, right? Well, no, the National Association of Realtors doesn't agree with you. Our organization doesn't agree with you. They want to have sales to anybody. They always just want to promote sales and making money. Okay, I think this one can be solved with a little bit of common sense. However, it did go to court in New Jersey, and the ending result was that 30-year-old can buy in a senior housing unit. They just can't live there. So what, they're going to be buying up units there and then renting them out at a marked up price to the seniors? Doesn't that kind of defeat the purpose of having senior housing? I think so. Now, I would say we could carve out one exception because you could always get people to start making arguments. Yeah, but I'm only 30 years old. I'm buying it for my senior parent or grandparent or whatever to live in. Okay, so we should have a carving that, you could be under 62 and buy in a senior housing community if you're buying it for a relative and you're not using it to mark up the price to make money off of seniors. Boom. Easy fix in the law, right? Only thing is, law doesn't use common sense. Have you seen politicians using much common sense in recent years? Probably not. So in this law here in New Jersey, it went to court. And they said, yeah, 55 plus communities, senior communities, you could be under that age and purchase and own units there. And that's exactly what people are doing. They're buying them, and then they're renting them out at a marked up price to those seniors, driving up the costs, kind of defeating the purpose of having the housing for older persons. Okay, so if 80% in a 55 plus community, if 80% of the units are occupied by at least one person 55 years or older, so can you have somebody that's under 55 living in a 55 plus community? Yes. As long as at least 80% of the units are occupied by at least one person 55 or older. Look, what if you're married and your spouse is 55 or older and you're younger? Or what if you're with your parent and they're 55 or older and you're an adult child of theirs? You know, they could have restrictions that they don't allow children under the age of 18, but what if you're an adult child of theirs? Can you live in a 55 plus community? Yeah. And what happens if that parent dies? Well, you could continue living there. You own the unit, you've been living there, you're allowed to continue. The community just needs to keep track that at least 80% of the units are owned and occupied by at least one person that's 55 or older. So that's how that works. So here's that question that was added to that New Jersey Realtors legal question library. Can a buyer younger than 55 years old purchase a property in a 55 plus community if they're going to rent it out to 55 plus tenants and the community allows rentals? Can each individual homeowner association determine a restriction on the age of the buyer? This became an argument, and NAR sued. So, under the Housing for Older Persons, let's see. It does permit communities to limit the occupancy of homes with age restricted communities to individuals who have attained that certain age, 55 or 62. Similarly, New Jersey law requires that all purchasers and grantees of homes in an age-restricted community certify that the homes will be occupied by individuals who meet those age restrictions. Neither the federal nor the state law requires the non-occupant owner or grantee to meet the age restriction. So you can be under that age and still buy, just can't live there. That being said, New Jersey Realtors is aware of homeowners associations and municipalities that have enacted governing documents and ordinances that require the owner to meet certain age restrictions, even if the owner would not be occupying the home. So in New Jersey Realtors' position that HOA regulations or municipal ordinances which prohibit non-occupying individuals 55 or 62 from owning a home in an age-restricted community, even when they certify that the occupant will meet that age requirement, they violate federal and state laws. For this reason, New Jersey Realtors is currently challenging the legality in court. All right, and so they did get an answer to it, and this is the answer. This matter was decided in appellate court in the township of Berkeley in July 2024. And it did say that you can be under that age and buy and own and rent out the unit to somebody who's 55 and older or 62 and older. All right, so
But there's a purpose there too. Like not every older person can afford a lump sum of money, and they want to live with the the age group. So by allowing somebody younger to rent it to them, kind of solves the problem.
provided that provided that they're not marking up the price so much that you can no longer afford it again, right?
But that's market forces decide that,
Yeah,
too
but
expensive, then people wouldn't live there.
but should they? Yeah, that's the argument. It becomes more of a moral argument. We have these. Why did we create 55 plus in communities and senior communities? The whole purpose was so that you could have a decent place to live. When the market forces drive up the cost of real estate everywhere, you could get you could get these nice properties for a cheaper amount because they're subsidized, maybe get tax breaks and such. And now you're getting people that are younger that are buying them and then marking up the prices to make money off of it, that selling it to or renting it to the seniors. You know, I personally think that they shouldn't be able to do that unless they're a family member and they're not making money off of it. Or let's get rid of the family member requirement. Sure, let them do it as long as they're not marking up the price and making money off of the seniors, because it kind of defeats the purpose of keeping the price down for the senior communities and 55 plus communities, you know, the housing for older persons. So at least that's my stance on it. But
I kind of,
Yeah.
sorry.
No,
I just not sure, like you're saying that, you know, with they marking up the price. I mean, we're all trying to kind of make the most out of what we can as realtors. So if somebody in that age group can afford to pay 4,000, okay, then, you know, that's the market price for that property. You know, I'm just not sure, like, definition of a markup or unethical or illegal markup in that situation.
if you're not the age and you're buying the unit so that you could rent it out to seniors to make money off of them, that's the whole case of a markup. You know,
But I was saying that, you know, some older people, they don't have lump sum of money or hard to get financing, but they have a few thousand, like they have a certain amount of thousands of dollars, and they say, listen, I'm gonna let me rent it out for a year and
Mhm.
let's live nicely, and they have that opportunity.
Yeah, it comes into, are they driving the cost up yet or not, though? I understand what you're saying. They may not have all the money to buy themselves, but there are
Yes.
senior communities where you could also rent, you
Mhm.
know. But then if that's the case, you know, are the rentals being driven up by the others because they're buying out all the units, you know? I mean, it's like an argument that this argument can go on and on forever, you know, of the different scenarios and, you know, having this um, uh, back and forth. Uh, Either way, the courts have determined that they can, and so as of now, that's the bottom line. And this was recent, you know.
But
Uh,
I guess your experience tells you that the net effect of this situation is that the older people end up paying more, and that's what you don't like.
and I've seen it. I've seen it. If you take a look, I've helped somebody actually just this past year. I helped a senior buy in a senior housing community. And there was nothing special. It was actually in New Brunswick. And that New Brunswick or was that Piscataway? I'm sorry, no, it was Piscataway. It was Piscataway, senior housing community, right over there by the college. Um, the price on it blew my mind. There's nothing special there as far as amenities go or anything. Um, the building, uh, nothing fancy about it, but the unit was over $500,000 for a 2 bedroom for seniors. In the meantime, I remember just a couple of years ago, not too long ago, in Monmouth County is full of senior housing communities and 55 plus communities. I remember seeing some 55 plus communities. I'm like, damn, I can't wait till I'm 55 because there's like right on the beach. You got townhouses right on the beach over there. And I was like, damn, that townhouse, if it wasn't a 55 plus community, it would be over $1 million. And in the meantime, I was looking at the prices and I was like, it's 350. I was like, damn, I can't wait till I'm 55. Yeah, so it's driven the prices up though.
So you are a little biased. I understand.
Yeah, in just a couple of years, it's driven up well, not even for me, I'm looking at it, well, yeah, I would love to do that. That'd be great as once you're 55 plus or a senior, I'm not 55 yet, close, but I'm not there yet. So it's not a matter of me being biased. I'm looking at it from their perspective, from the seniors, I'm trying to put myself in their shoes, how it's driven up the costs I've seen.
Okay. I understand.
By the way, not for it because they just wanted more sales. They don't care who's buying it. They just want the sales and the prices to go up because hell, that's what their industry is. All right, so uh, senior housing is 55, 62 and older strictly, and 55 and older is the 55 plus community. That's housing. Either way, they're both fall under the category of HOPA, housing for older persons. And the Garden State MLS, like other MLSs, well, some MLSs now, they don't require any paperwork, but except for this, if it's something that's age restricted, if you're going to be offering a property that's age restricted, you need to have this form filled out. Now, in the past, until this recent lawsuit, they were requiring this form for you to be able to buy the property. So you would say when you put it up for sale, it's age restricted. You're not allowed to, you're not allowed to if you don't meet the age requirement. So now they could still buy, you just can't occupy. So this is the form here where you got the property and the management, the property address, the management facility, the owners, and the broker have to put their info here. It says that this property is housing for older persons, and you're going to check off if it's a 55 plus community or seniors. The underside hereby certifies the designation of this property as a housing for older persons with a specified age restriction is correct. Because if we put the listing in the MLS and we said that it's age restricted, and we did not have this form filled out, then we're discriminating against those who have children. You know, so you had to certify that it was housing meant for older persons, so it's not. I guess this would only really be needed anymore for rentals, right? Or for no, actually, you could have it for purchases too, as long as the purchaser knows that they can't occupy it. All right.
And what does occupy really mean? Is it like a certain amount of days they need to reside there, or what if
Yeah.
they just visiting?
Yeah, you're living there at all. Staying there, living. Yeah.
Okay.
All right, service animals. We hear a lot about this. Everybody loves their pets, right? And sometimes it could be an issue. You give people an inch, they take 10 miles, right? So there's something called the FHA. This is not the Federal Housing Administration. This is a law of the Fair Housing. It makes it unlawful for housing providers to refuse to make a reasonable accommodation that a person with a disability that they may need in order to have equal opportunity to enjoy that housing. So assistance animals are not pets. They work, they perform tasks, they assist and or provide therapeutic or emotional support for their individuals with disabilities. Consider the assistive animals as part of the person's disability. So if you don't allow people with a disability, you're discriminating against them. So if you don't allow people who need a service animal to help their disability, well, you're discriminating against their disability. That's how it works, basically. Now, there's two types of assistance animals. You have service animals, which are which are trained to perform tasks. You know, like we know seeing eye dogs, they help their blind person. There's also animals that are trained to sniff out if your blood sugar is running low, if you're in danger of having a seizure or other types of disabilities, right? They're there to do a task, and usually these dogs are larger dogs. They're not lap dogs. Those ones that are trained to do things, because they're usually there to lean against you and push against you to hold you up or to signal to you, hey, it's time to sit down, you know, and they got to be obvious about it. Emotional support animals, they don't require any kind of training. Emotional support animals, just the fact of having them there, that you could pet them, calms you, soothes you. It's good for people with PTSD and all kinds of other stuff like that. Emotional problems and disorders. It helps with coping with depression, severe anxiety, and phobias. So just having that ESA, that emotional support animal there, can help you with your disability. So landlords may not inquire as to the nature of the person's need, only the right to verify that the letter from the therapist is real and that the therapist is licensed and confirms that the tenant needs an emotional support animal. So they can't ask you what's your problem? What's your disability? They could just ask for a letter from your doctor to basically the prescription that says that you have a need for an emotional support animal. That's it. And then even if they have a no pets policy, they can't deny that emotional support animal. They can't charge you additional fees for having a pet because it's not a pet. It's a service animal, right? They can't charge you, well, security deposit you could charge to anybody. So be careful when you call it pet security and it's an emotional support animal or service animal, because, well, it's not a pet. So be careful with that. You just charge security. There's limitations in New Jersey on how much you could charge for security. It's 1.5 times the monthly rental figure. And you can't charge pet security on top of that. It maxes out at 1.5 times. And what is security deposit for? When a tenant doesn't pay or when they cause damages, right? So you don't need to call it pet security, just call it security and you're good. So can you charge security when you have a service animal? Sure. It's security. Has nothing to do with the animal per se, right? So shops, businesses, and public buildings such as courts and libraries are legally required to admit service animals, even if their general policy is that there's a no dogs policy allowed inside. However, they are not required to accept emotional support animals anymore. Same thing with planes, bars and restaurants, beaches. People love their animals and you're limited in what you could ask somebody with a disability. You could say, is that a service animal? And only landlords can ask for proof. So pretty much you can only ask, like if it's a business, is that a service animal? And what tasks are they trained to perform? You're basically crossing off the list that they're not emotional support animals, because emotional support animals do not need to be let into public accommodations. Only service animals do, the ones that perform tasks. Now, airlines, however, they can require a letter from the therapist or doctor, the prescription. And so I got a couple slides here that talk about that same thing, get into the details of it. Now, there's no official certification or training for assistance animals. They could assist in a wide variety of ways, and breed and weight restrictions do not apply to assistance or service animals. So yeah, even a pit bull can be an assistance animal. So before you go telling them they can't have it, you better consult with your attorney. Landlords, you got to provide that reasonable accommodation. If you don't, and they got that letter from their doctor, nothing you could do. You have to allow it, unless it would cause an undue burden on the landlord. Consult with an attorney as to what an undue burden is. You need to consult with an attorney that specializes in this stuff. Maybe the costs or some other thing. I don't know. I'm not going to get into that. I don't know. I'm not a lawyer. All right, so what's the difference between service animals and assistance animals? Assistance animals can be trained to perform tasks, but they could also just be for emotional support. Service animals can only be dogs, or in some cases, miniature horses. Yes, a miniature horse. Anybody ever have a miniature horse next to them on a plane? It's allowed. And if that's the case, the airline also depend if the flight is longer than 2 hours, the airline has to make an area on the plane where that service animal can relieve itself. What a predicament we put ourselves in when we start allowing stuff like that, though, you know? So, little miniature horse there. So, an ESA, emotional support animal, can be anything: cat, dog, bird, whatever. You know, if they're assisting and they're performing some kind of task for you, here's some examples where they could detect and alert the companion to oncoming seizures, or alleviate the person's depression or anxiety, or reduce their person's stress-induced pain. Or a bird can alert the hard of hearing companion when someone's come to the door and rang the doorbell that you didn't hear. Their squawking could get your attention. Check out this dog. I got a little video here of this dog. Look at this dog trained and alerting. This is a service animal, an assistance animal that's actually trained to do a task. They're trained to sense when their owner's blood sugar level has dropped. And check it out.
Oh, is it going low? Lovely. Let's see. Halfway down. Good boy.
Look at that face. Booja, booja, booja. But you see how they're usually larger animals like that. Like he had to hit her with a snout. Hey, check your blood sugar. Check your blood sugar. They're amazing, these animals, how their noses can sense your blood sugar levels are getting to dangerous levels. I got more videos of different types of issues with service animals. It's amazing. I could add some more, and I will once I put them on our YouTube page there. But either way, there you go. There's an example of that. So demonstrating your pet's a service animal, all you need is a letter from the therapist. And if your landlord refuses, well, you could file a complaint under federal law or state law. State law, you'd file that complaint with your local attorney general's office. Federal law, you'd file that complaint with HUD. And listen, what kind of housing does this pertain to, though? So all types of housing, including public housing, are covered by the FHA, the Fair Housing Act, except rental dwellings with 3 units or less if the owner occupies one of the units. Single-family homes sold or rented by the owner without the use of a broker. This first one can actually be reworded a little better. Rental dwellings with 3 units or less. With 3 rental units. No, that's good. Housing owned by private clubs or religious organizations that restrict the occupancy to its members. Pets cannot be charged additional rent, additional fees. Security deposits, well, just don't call it pet security. You're good. So, the owner may still seek money from a tenant if their animal causes damages to the home beyond the security deposit amount. And if there's a nuisance issue, because you could have emotional support animals in your residential real estate, if there's a nuisance issue that you can control your animal, the landlord can take the tenant to court and have them removed through legal proceedings. So here's a question that I got from that NJ Realtor legal library. Is it legal to charge a dog, pet, or animal fee when renting an apartment? And what's the answer to that? No. Can't charge additional pet security either. Here's an additional thing. Any additional security deposit increases collected annually shall not be greater than 10% of the current security deposit. Security deposit law applies to most residential rental properties, including mobile homes. The exception is an owner-occupied 2 or 3 family dwelling. Okay. So, see if you guys can answer this. John has been diagnosed with a severe depression and is disabled as defined by the Fair Housing Act. His doctor prescribes John a dog to help alleviate some of his symptoms. And John asks his landlord if he could have a dog as a reasonable accommodation for his disability. His landlord says yes, but then tells John he needs to pay a $250 pet deposit and must provide proof the animal's trained. So, did John's landlord handle this request correctly under the Fair Housing Act? And what if John wanted a cat or ferret instead? What say you? What do you think? Did John's landlord handle that request properly?
I don't
No.
think so.
And why not?
Because they cannot charge.
Yeah, they can't charge a $250 fee or a
Okay.
pet fee.
Okay. What about providing proof that the animal's trained?
I don't think you can do that either.
You can't. You know why? It discriminates against poor people who may not be able to afford a $50,000 training for a dog, a trained dog. What if they have the ability to train the pet themselves, be a service animal, right? So that was what the argument was behind that. Now, what if you wanted a cat or ferret instead?
He can have, I think.
Yeah, for emotional support, you can.
Yeah.
For service animals, though, service animals, they can only be dogs or miniature horses. So the answer is no. John's landlord didn't handle the request correct. The landlord cannot charge that pet deposit because the animal's not a pet, but a service or companion animal required for the disability. And further, the landlord cannot ask for proof the animal's trained. Lastly, the companion or assistance animals do not have to be just dogs. They can also be other animals like cats or ferrets or birds.
So I got a question about that.
Yeah, go, shoot.
But what can the landlord ask for? Like, can he ask for like the documentation for his disability at that point?
Yeah, you could ask, wait, who, the landlord, right?
The landlord, yeah.
Landlords can require every year you provide it because it is a prescription from a doctor, and sometimes prescriptions expire and are not renewable, right? Sometimes you only need it for temporary time. So if that prescription's only good for so long, they could require you on the renewal of the lease to provide another letter from your doctor or therapist. Yeah.
Okay, that makes sense. Thank
Um,
you.
Let me put, because I see somebody else, somebody needs to go right now. So let me put in there the before lunch attendance poll.
So can landlords not charge, like, if you say any pet's like an emotional support animal, can you not charge them for any sort of animal? Or is it like specific?
They're needed for your medical need, whether it is because you're blind or they're performing a task. If they're a service animal or an emotional support animal, emotional support animal is needed for not to necessarily perform tasks other than just be there for your mental health and well-being.
Okay.
But if you need that, you could get a letter from your doctor or therapist. I was going to wait until after lunch for this. So, but before I do, let me throw this video on. We'll watch this video and then we'll break for lunch. Okay. This will probably help answer some of your questions too.
The largest airline to crack down on the so-called emotional support animals.
This is from a couple of years back. I found this online, so I just use this.
Since that song. The policy change was prompted in part by a passenger who tried to board a United flight with a large peacock on Sunday. Delta announced similar restrictions just last month. CBS News travel editor Peter Greenberg is at United's hub at Newark Liberty International Airport, and that's where that peacock was grounded. Peter, good morning. Most people don't think of peacocks as emotional support animals.
No, but they are. In fact, more and more airlines are reporting that the number as well as the types of emotional support animals is reaching crisis proportions. Now, we're not just talking, as you can imagine, dogs and cats. In fact, the interior cabins of some flights are beginning to resemble Noah's Ark.
I'm not kidding. This woman is wrangling her peacock into the airport.
United Airlines says it warned the peacock's owner 3 times that Dexter would not be allowed to board. The bird lives with an artist in Brooklyn who claimed Dexter was her emotional support animal. In this 2016 interview, she described how she found him.
Now, before she starts describing how she found it, you tell me if this lady really has a medical need for this, or she just got attached to this animal and now wants to. She's artsy fartsy. She wants to have it with her all the time and be different. And she got a letter from her doctor because that's not too hard to do, to have the animal with her. But does she really have a medical need for it? I highly doubt it.
Originally for an art project, and but then
she got the animal as an art project originally.
This happened, and I was like, "Do I have a peacock currently in my neck?"
Yeah.
Yes, I do.
United Airlines already prohibits non-household birds, hedgehogs, ferrets, spiders, sugar gliders, and other exotic animals. Its new policy requires owners to give 48 hours advance notice when flying with a support animal, provide a letter from a mental health professional, and documents from a veterinarian showing the animal is vaccinated and not a threat to the public.
We've had roosters and ducks and pigs and monkeys.
Sarah Nelson is the president of the Association of Flight Attendants and says she applauds the new policy changes.
But what we really need is for the Department of Transportation to act with guidelines for the entire industry.
United saw a 75% spike in comfort animals, from 43,000 in 2016 to 76,000 last year. The critters sometimes relieve themselves in damaged planes. In June, an emotional support dog bit a Delta passenger. Can pigs fly? In 2015, we showed how easy it was to get one on a flight. A Colorado counseling center provided CBS This Morning with a letter prescribing the pig as the primary treatment for a psychological disability. Tom Panic, CEO of Guiding Eyes to the Blind, says people are passing off their untrained pets as service animals.
As a person who is blind, my access rights are being infringed upon when somebody passes off a fake service dog.
Now, the new policies for United and Delta kick in on March 1st, and American Airlines is expected to follow suit. But we should note that the new policies only apply to emotional support animals, not the trained, specially dedicated animals that fly for and with people with disabilities. John?
Peter, thanks.
Yeah, people take their pets very seriously. We get it. But you see a lot of people taking advantage of that policy. So I think it's good that they're trying to figure out a way to crack down and make sure that the legit animals go.
Yeah, because people want to just take their animals on and just say, because they know you can't ask for proof. So they say, oh, yeah, it's an emotional support animal or service animal. So now emotional support animals are not required to be allowed in planes. So only the service animals that perform a function are, otherwise emotional support animals, you could put them in the cargo hatch or, just like you would transport any other pet. Okay. And there's basically the guide on that, where are they allowed and where are they not allowed. So those emotional support animals, also referred to as assistance animals sometimes, they don't have to be allowed in public access areas or air travel. They don't need to be trained or registered or certified. The service animals that are required to be allowed with you on planes and public accommodations, they do have access rights, air travel rights, housing rights. they do get trained, but there's no certified certain training they need to get. You could train them, or you could have professional training done. And so there's no registration or certification for either of them. There's no permit, no license, no enough paperwork you need to carry around. They don't need to have the vests that say service animal on them. They don't need that if you have a service animal. Let's break for lunch now. Let me pause the recording. The Equal Housing Opportunity poster. This needs to be displayed in the offices of anybody that offers housing or housing services. If you fail to display this, it is considered evidence of discrimination. So simply not displaying the Equal Housing Opportunity poster in your offices of your brokerage firm or where any place where somebody's offering housing or housing services is considered evidence that you engage in discriminatory practices under the federal law. All right, so the threshold is not too stiff there to be found guilty of discrimination, right? All you got to do is not have a poster about the equal housing opportunity, and you're guilty of discrimination. So let's do these highlights on 7071 that the Federal Housing Act of 1968 instituted the use of an equal housing opportunity poster. When HUD investigates a broker for discriminatory practices, it considers failure to display that poster. It's evidence that you are engaging in discriminatory practices. And I got this, you don't got to go to page 86 and highlight this now, but it says the complaint does not have to prove guilty knowledge or specific intent in order to be found guilty of discrimination, only the fact that discrimination had occurred. There's a lot of low thresholds. The bar is pretty low in order to be found guilty of discrimination. And you can see that here, not having a poster in your office, guilty of discrimination. Okay. It doesn't matter what your intent is. In order to be found guilty of discrimination, someone just needs to show that a discriminatory act had occurred. And then, boom, you're guilty of discrimination. This is the Equal Housing Opportunity poster, the house with the equal sign in it, right? You all seen this before? Probably that logo, at least you've seen, but this is the poster that needs to be displayed in your offices. If it's not displayed in your offices and somebody files a complaint against discrimination, boom, you're guilty. They stop their investigation. You're guilty of discrimination by not having this poster. That serves as their evidence. Page 72. Let's do the highlighting on block busting, steering, and redlining here. I'll have better definitions coming up. Another page.
I got it.
All right.
Got it.
So 1960, the Fair Housing Act of 1968 makes these practices illegal, although they're not mentioned by name in the law. Block busting, sometimes referred to as panic peddling, is using, this is the definition as I've been explaining it to you, not as it was written in the book. Using discrimination as the tool to play on the homeowner's fears of a protected class, that these people, fill in the protected class, are moving into the neighborhood in order to scare them into selling. And they do that, they create some kind of a panic, scary story to try to scare the homeowner into selling their home. That's trying to get them to bust up the block and move, right? That's why they call it block busting. And panic peddling, because they tell you scary stories. Okay. Steering is limiting someone's options of where they can live by not showing them all the properties that meet the criteria in the areas where they're looking, or by channeling those home seekers to or away from certain areas. You know what? I think you'd like it better in here, in this neighborhood. I think you'd like it over here. You probably shouldn't look over there. That's a whatever area. This area is probably better for you. I think you'd like it better over here. You know, by doing that, when you're the one that's deciding where someone should live, or you're trying to gently or forcefully push them in one direction, or by doing it in a way where you're just not even letting them know that there's properties available in another area. When you're the one that's steering them to one direction or another, that's steering. That's illegal under federal law. So when the agent is the one that decides where the buyer or renter should live, that could be deemed a discriminatory act. And lastly, redlining is refusing to give financing or mortgage loans or insurance policies, even though the person could afford it, as a means of discrimination. So these are probably the simplest, most direct definitions, explanations of these three things to understand what they are. You do need to know them for exam. What is blockbusting? What is it also known as? Panic peddling. Who does it discriminate against? The owner. You're forcing them to bust up the block by telling them scary stories, spreading your panic. Steering is discrimination against who do you drive in a car in the real estate industry? Buyers and renters, you drive them around. You don't drive sellers around, right? So who are you discriminating against when you steer? Who are you steering around? Buyers and renters. You're driving them around, right? I think you'd like it in this neighborhood better, or I think you'd like it over here better. Think of it that way to get a visualization in your head. So steering is discrimination against those buyers or renters by limiting their options or telling them, you know, when you're the one that's trying to make the decision of where they should live. And then redlining is dealing with the financing, the mortgage loan, the insurance, or an insurance policy. Even though the person can afford it, you're not giving it to them. All right. Here's a little video clip from a documentary that really gives you the true meaning of where the term redlining comes from. The term redlining comes from these maps that insurance companies and lenders actually drew based on the population of who lives in areas and stuff to show which are the higher risk areas. You know, minorities, foreigners, those are considered redlined areas on a map. They would draw a red line around the map showing that these are the higher or riskier areas. Watch, I'll let the video speak for itself. Here you go.
In the 1930s, in the wake of the Great Depression, FDR is president. He wants to bring economic relief to millions of Americans through a collection of federal programs and projects called the New Deal. One part of that New Deal was the National Housing Act of 1934, which introduced ideas like the 30-year mortgage and low fixed interest rates.
Wow. Look at that. $4,800 for a house. You got to put $960 down and $27.62 per month mortgage payment. Yeah, that's back in the day when you could order a house out of Sears catalog too. Oh, does anybody know what Sears is? Yeah,
And what year is this again?
What, in 1963, they said?
So now you have all
When they had that the New Deal. The New Deal. Yeah. Look, today you have people that are also pushing like the Green Deal and this deal and that deal. We want to have a new version of this deal. A lot of times you're seeing that in Congress, you know, the AOCs and people like that. They're like, yeah, we need these infrastructure bills. And then they pass this, what's it, $1.4 trillion infrastructure bill. And yet not a penny of it has been spent on bridges or roads. You know, they actually called it the social infrastructure bill, whatever the hell a social infrastructure is, you know, and we know what it is. It was to put housing for illegals and benefits and do things like that. The money went to different things, had nothing to do with the actual infrastructure of fixing our crumbling roads and tunnels and bridges, you know. But this is how they were peddling it to us. All these politicians during the Biden administration, they were pushing it. They were like, "Yeah, we need a new deal." You guys remember that? They're talking about a new deal, like FDR did. This is what they were talking about.
All these lower income people who can afford homes. But how do you make sure they don't default on their new mortgages? Enter the Homeowners Loan Corporation. The HOLC created residential security maps, and these maps, they're where the term redlining comes from. Green meant best area, best people, aka businessmen. Blue meant good people, like white-collar families. Yellow meant a declining area with working class families. And red meant detrimental influences, hazardous, like foreign-born people, low-class whites, and most significantly, Negroes. Again and again on these HOLC maps, one of the most consistent criteria for redline neighborhoods is the presence of Black and brown people. Let's be clear. Studies show that people who lived in redlined areas were not necessarily more likely to default on their mortgage.
That's where the term redline.
Алекс, вот этот, который нарезать, от которого он здесь приходил там.
Make sure you mute.
Hanging у нас получится, нет?
What are you talking?
There we go. I'll mute you. Make sure if you're having a conversation, you guys mute that stuff, okay? I'm recording these things here. All right.
The 1930s.
Okay, now let's talk about something called disparate impact or disparate treatment. Often this is being used to pass a lot of laws today. Disparate impact, sometimes, now both of these things, if you listen to it and you look at the way that they try to interpret it to people, it's pretty shifty way to try to get politicians to pass whatever agenda it is that they want in the laws. They try to paint the picture for you that disparate impact is negatively impacting somebody because of the way that they're treated. Now, they'll say a bunch of things that you could agree with, that everybody can agree with, and everybody's nodding their head up and down with. And then they'll start to like push the envelope a little bit on it. And then it's like, what are you talking about? To try to get an agenda in there. You'll see what I'm talking about here. Disparate impact, sometimes referenced as disparate treatment or adverse impact, is a policy or practice that seems to be neutral, but in fact, it may disproportionately impact certain groups of people. This results in discriminatory practices, resulting in unequal treatment and hindering equal access. For example, a lender or property management company may require full-time employment. On the surface, this requirement seems fair. However, it discriminates against someone receiving public assistance, disability payments, etc. The Department of Housing and Urban Development enforces the Fair Housing Act of 1968. Yeah, that is true. They do. So what? What's the point? They published a guidance explaining the use of criminal history to exclude people from housing. Now, when did they do that? They actually did that during Obama's first administration term. He appointed somebody into HUD to take a head count of people in prison and segregate them by their color so that they could paint the picture that there's not an equal number of white people in prison versus people of color, right? And then they take the leap that because there's not an equal number of white people versus people of color in prison, that means the criminal justice system is inherently racist and unequally or systemically racist in how they go about arresting people or incarcerating people. All right, well, look, even if you want to go with that argument, which isn't true, but if you want to go with that argument, you could say, yeah, maybe there's some racist cops. Sure, they unfairly arrested people. They still got to go before a jury of their peers and get convicted and then go to prison. Did they commit the crime or not is all I care about. I don't care what your race is. I care about if you committed the crime. Then you may belong in prison, right? But this doesn't do that. This just looks at, well, the total number is not an equal number of people based on their color that are in prison. So therefore, if you got more of these people in prison than those people, this criminal justice system is inherently racist. And therefore, if you rely on criminal background checks now based on people's convictions, you are now racist because you're relying on information that's based on something that was racist, which that hasn't been proven, because the only thing that's been proven is that there's more of these people in prison than these people. Okay, now did they commit the crimes? How come they're not asking that question? That would probably be the important question factor to ask, right? Did the people actually commit those crimes? And then why? You know, I mean, we do know that something seriously happened in the past from the 60s to now. In the 60s, our prisons weren't full of people of color. Why are we seeing that now? I mean, there's a lot of social aspects to that we don't really need to get into, but it comes into absentee fathers or whatever in the home and things of that nature that may be the cause of some of this stuff, one-parent families and all kinds of things. But that's a social thing. But they never considered that when putting out these reports, you know, the root of the causes. Instead, they just like to blame it on the criminal justice system so that they could paint their own pictures today. So now they're actually passing laws. When I say they, the politicians are passing laws for whatever agendas that they have. Now, the housing providers may not use criminal history as a pretext for intentionally discriminating. Yeah, they shouldn't. Based on their person's race. Yeah, they shouldn't. This is what they should do. If you're going to do a criminal background check, you do it equally to everybody. You don't just do criminal background checks on black people, but not on white people, for example. If you can do a criminal background check, you do it on everybody, right? So applying a criminal record-based restriction against protected classes differently than they apply them to non-protected housing applicants. Yeah, well, that's straight up. That is straight up racist. You don't do that. If you can do a criminal background check, you do it on everybody. For example, a management company with an intent of keeping all tenants safe may reject an applicant based on their criminal history. This ignores groups of people that are incarcerated at higher rates. Whoa, 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 whoa. We're not renting an apartment to groups of people. We're renting them to a person. Are we relieving everybody of their own personal responsibility? Did you commit a crime that you went to jail for? Then you should be able to have that held against you. It's not, see, they're trying to obfuscate this by saying, well, you're ignoring groups that are incarcerated at higher rates. Well, what does that have to do with this? Now you're trying to lump everybody in that all people are the same based on their color. You know, that's not the case. We're doing criminal background checks on you as an individual. So it's trying to mix that up a little bit, blur those lines. So the general population incarcerated at higher rates than the general population, and they may not result in a safer environment. I don't know. Looking at an individual who's been locked up versus for committing serious crimes versus one who hasn't, you be your judge. How about this? I don't care what your color is. If you're black, white, Hispanic, Asian, this, that, or the other thing, it doesn't matter. You guys, to protect yourselves and your family, people of your same, look at only people of your own race, your same race, okay? If you look at people only at your same race and you do a criminal background check on only the people of your same race, okay? Let's look at it from that perspective. Would you want to rent to one who has a serious criminal background check or one who doesn't have a serious criminal history? They're the same race as you. We're not even crossing racial barriers right now. We're just saying the same race as you. You got two people that want to rent your apartment, the same race as you. Okay, so we're not even crossing into discrimination or racial things. Okay, One you did a background check on, they got a criminal background check, one they didn't. Which one would you feel safer renting to? The one with the serious criminal history or the one without it?
Clean record.
The one without it.
You know, so this crosses those racial barriers. This has nothing to do with race. Politicians are trying to make it about race. You know, I've had people in this class from all different backgrounds, and when I have these conversations with people, see, that's the thing, we don't have conversations, we talk at each other all the time. But when we have these conversations, especially people who have families and have children, and what do you feel safe, or who do you feel safe around? You know, we all seem to come up with the same pretty much consensus. We all, looking out for the safety of our families and relatives. The only people that I had really that had a little different view on it were people who had people close to them in their family that were convicted felons for something. And then they're like, oh yeah, but then they need a place to live too. You know, it's like, okay, I understand the argument, but the property owner should not have to rent to you, regardless of your criminal history. Okay, there should be consequences for the actions of what you did. You know, so yet another example. Now here's another one. They really get way off base on this one. Here's another example of that disparate impact treatment. They say another example of this is a zero tolerance of violence. Okay, yeah, I understand zero tolerance for violence, without recognizing that perhaps 25% of women have experienced domestic assault. Okay, so what are you getting at? They're the victim. So this policy would negatively impact them. Say what? They're trying to paint a picture here that, hey, if you've been the victim of violence, a zero tolerance for violence would not allow them to rent to you? No. Do victims get arrested? Generally not. That would be the perpetrator that was impacting that violence on the woman that should get arrested, right? And they should have those consequences. See how they're trying to blur the lines about disparate impact, saying that, well, you may get negatively affected because you were a victim of violence. No, you wouldn't. There wouldn't be a criminal record on you for that. This is like in high school, maybe. They kick you out of school for the day because you two were fighting. And criminal records don't go down and work like that. Anyway, continuing on. So therefore, based on that disparate impact nonsense, the way that they could twist it a little bit, or a lot, our politicians passed this law called the New Jersey Fair Chance in Housing Act, the FCHA. Remember I told you New Jersey politicians made criminals a protected class? Now they specifically say this does not make criminals a protected class, but then they go on to explain how criminals are a protected class. Beginning in January 1st, 2022, New Jersey Fair Chance in Housing Act prohibits landlords from generally asking about criminal history on your application. You can't do it anymore. In these cases, landlords are prohibited from running a criminal background check on an applicant until you first agree to rent to them. You got to give them what's called a conditional offer of housing. Okay? But you can't tell people that you're going to do a background check on them in advance because that could possibly scare them away. So here's my 2 cents. This is my interpretation. These are my words of explaining this. What do we do now when these laws are written like this? Well, the best we could do with contradictory guidance is to be a good person, treat everyone equally, fair and just. Hopefully you're not going to get sued in the process. Politicians, in the name of fair housing and something that they call equity, not equality, but equity, are justifying a systemic racism claim by absolving individuals from their personal responsibility and accountability for their own actions. Instead, they're judging individuals based on the racial groups that they fall into. As you see, we read it right there from the book. they fall into as the reason to excuse them for their criminal activities in the past. So law-abiding citizens wanting to safeguard their family, protect their tenants, which they still have a legal responsibility to if you're a landlord. You have a legal, which blows my mind. How are you going to do this? You have a legal responsibility to safeguard your tenants from other possible violent or other tenants who could cause problems for your other tenants. You have a responsibility to do that. However, you're not allowed to do the background checks on them and such. So the property and tenants have a responsibility to do so. They could be found guilty of discrimination for denying renters who do have a criminal history. It sounds crazy, but that's now the law in New Jersey. Now, that's my interpretation. That's my 2 cents. Don't believe me, though. Let's look into what the law actually says. Make up your own minds. I'm not trying to convince you of anything. First, before we start getting into the New Jersey document that actually we give to people about the Fair Chance in Housing Act, I'm going to let this non-attorney explain it. Now, she goes through the explanation, and if you listen closely to what she says, she's contradicting herself multiple times. And a lot of times when they're talking about these disparate impact and disparate treatment, they're not talking about people actually being found guilty of something. They're just saying people were accused of crimes or people were accused of something, and then landlords settled cases. Yeah, people settle cases all the time because it costs less to settle out of court than to go through with the whole thing. They're not admitting guilt or anything. Watch this. Listen to this.
Welcome to Window to the Law. I am Mame Nyamiche, staff attorney at the National Association of Realtors.
I'm sorry, I'm just want to make sure that the volume is set right. Yep, it is.
In this episode, I will discuss why it is important to give your criminal background screening practices a second look in order to avoid a fair housing violation. In fact, several housing providers have found themselves faced with lawsuits alleging the misuse of criminal history in violation of fair housing laws. In New York, a housing provider recently settled a case for over $1 million, where the plaintiff alleged that the housing provider maintained an overly broad ban on renting to people with criminal records.
Okay, so somebody settled a lawsuit because they had an overly broad ban on people with criminal records. Whatever that means. So we don't want to rent to anybody with a criminal record. Well, no, can't do that.
In Florida, as many as 48 Florida housing providers were also sued for the alleged improper criminal background screening of prospective tenants.
So they were sued. So what? What was the result?
The use of criminal histories to make housing decisions has long been on the fair housing advocates' radars. In 2016, HUD issued guidance urging housing providers to exercise caution when implementing criminal history policies and practices to make housing decisions.
That was based on that report that President Obama employee into HUD created. See, all this stuff is recent.
In the guidance, HUD reported that African Americans and Hispanics are arrested, convicted, and incarcerated at disproportionate rates compared to the general population.
So what? Did they commit the crime or not? That's all I care about.
Resulting in criminal history-based barriers to housing and creating a disproportionate impact on minorities. While persons with criminal records are not a protected class under the Fair Housing Act, race, color, and national origin are.
Okay, so criminals are not a protected class, but race, color, and national origin are, is what she said. Okay, let's continue.
And the improper use of criminal history to make housing decisions may have a disparate impact on those protected classes.
So what is an inappropriate use of background checks?
Under a disparate impact analysis, a housing provider may be held liable for discriminating against a protected class absent any evidence of intent or motivation to discriminate.
Did you hear that? A housing provider can be found guilty absent of any evidence of intent or motivation to discriminate.
Meaning, liability may arise when a facially neutral policy or practice has or predictably would result in a disproportionately negative impact on a protected class under the Fair Housing Act.
So, in summary, if you do a neutral background check, you have a neutral policy, you're not looking at anybody's color or background or anything, you just do the same policy across the board to everybody, you could still be found guilty of discrimination, even though there's no evidence of it, no intent of it, just because people get impacted differently because the criminal justice system has more of these people in jail than those people in jail. See, I thought we were always taught not to group people as a group, as a whole, as a monolith, you know, having white people versus black people. It's just the individual accountable for their actions. Judge them by their integrity, you know, not by the color of their skin and all that stuff. Remember? Martin Luther King was saying that.
Some states and localities, such as Illinois, New Jersey, and the District of Columbia, have even enacted laws restricting a housing provider's use of criminal records. Consider these best practices when using criminal history to make housing decisions. Have a written criminal history policy. Apply criminal record policies consistently. Do not ask or consider arrests without convictions. Avoid blanket bans on applicants with a criminal conviction. Be sure to exclude only those with convictions that present a demonstrable risk to resident safety or property.
How do you do that? How do you demonstrate a demonstrable risk to resident safety or property? I mean, isn't that the whole point of doing a background check? They've done it in the past, so...
Document housing decisions, and become familiar with local and state laws that apply to a housing provider's use of criminal histories. For more information on use of criminal history in housing, check out NAR's article on fair housing and criminal history-based practices and policies. Thank you for watching this episode.
It makes it very difficult for us, sort of having a law degree, to determine who you can and who you can't turn down. Now, once again, before we start getting into the New Jersey specific Fair Chance in Housing Act law, and we're actually going to go over the New Jersey law against discrimination by reading the Attorney General's memorandum that we have to give to owners anytime we get a listing. It basically tells them that they cannot discriminate. They have to follow both state and federal laws. And then it goes over specific instances and examples. But before we go over that, let's use this example to show you how some agent was caught discriminating in an undercover sting by a reporter. This reporter, he's a young guy. He went to college. His college roommate was a black guy. He ended up using him as part of his investigation. He was marrying a black woman, but the person where he was looking for housing, he didn't have his fiance with him, so he went on his own. And he listened to how the lady was talking to him, and he got the idea that she was discriminating. So he started sending in single people, couples, mixed couples, people of different races. He even sent in his college roommate buddy there, who was a black guy, to see how she treated them. And then they take it over and they bring these videos over to an investigator at HUD. They open investigations. They go over what actually, you see this from the beginning through to the end of what actually the consequences are when a real estate agent gets involved in discrimination. This is an older video, but I like it because it shows you all of these steps that I've been teaching you so far. So...
high rise in Colombia. No African Americans living there. Is there a reason? Good evening, and thanks for being with us. I'm J.R. Berry.
And I'm Darcy Strickland. The reason could lie with one real estate agent. A News 19 investigation uncovered what appears to be active discrimination inside a prominent Columbia high-rise.
News 19's Johnny Chappell has been working on this story for months now, and he joins us with the details.
A lot of us here have put a lot of work into this story, and we hope that we can bring some possible good out of it, J.R. and Darcy. Who has the right to tell you where you can live? In January, I started looking to buy a new home. The very first place I visited, a realtor told me that for 25 years, the building had remained exclusively white. Her comment sparked our investigation, and our investigation has the federal government looking to take action. Looking up from anywhere between 5 Points and downtown, it's hard to miss. 1829 Senate Street, a 30-year-old high-rise, 19 stories of high-end housing. In all, 96 luxury condos. The Heritage, all white on the outside, and there's a woman who may be trying to keep it all white on the inside.
We do not have a mixed neighborhood here.
Ann Bryant is a longtime Heritage resident. She's also a realtor, and she shows just about every property that comes up for sale in the building. After my experience, we sent a team to investigate.
You get 7, that's good. I'm going to take you to see my son's unit first. Okay.
A News 19 employee and her sister told Bryant they wanted to see what was available. Bryant showed them 2 occupied condos before going inside a condo for sale on the 12th floor. At the time, the residence was not on the market. Bryant said she thought it would list for around $170,000.
When I have a listing anymore, I may not even put it in the computer because it's just, they go like that.
And
Whoa, wait a minute. She gets a listing, she doesn't even put it in the computer. When we get a listing, how soon do we need to put it in the MLS?
Within 48 hours.
48 hours, that's correct.
She said that all prospective clients and their realtors go through her.
I meet people to show in the building. If it's another agent showing, I meet them.
Bryant went on to indicate that race determines whether she allows a person to see or inquire about purchasing property.
And I'm very careful when I make this statement. We do not have a mixed neighborhood here. And I think that is because we try to be careful, and we try to not that nobody dislikes them. I work with them all the time. It's just that they tend to, I'm talking too much. They make a neighborhood go down because they don't take care of their yards, and they different.
She makes those differences appear black and white.
We do have some Orientals in one of the penthouses been here for years, nice as they can be.
Those statements marked the 3rd time we had heard Bryant referring to possible discrimination. She said it to me during my visit and to another News 19 employee during a previous trip. We showed the tape to Dudley Gregory, who's with the U.S. Department of Housing and Urban Development.
That conversation is enough to give me pause, and that I would want to look further.
Gregory said Bryant's behavior very likely violates a federal law. Under the Fair Housing Act, a realtor cannot discriminate in 7 protected areas, including race.
The issue is how many people have been to that place that are minorities that have been denied to even come through the door.
Local realtor Shelby King says those licensed in her field must complete class time every 2 years to keep up to date on the Fair Housing Act.
We are reminded about fair housing constantly.
King cites standard clauses in buyers and sellers agreements that deal with the law. She says there are certain things a realtor cannot discuss when showing a property, and that sometimes she's had to steer clear of a client's questions.
And they will usually preface the statement with, I'm not prejudiced, but what's the mix of the neighborhood? And I cannot address that.
So why would Ann Bryant, who's required by her profession to adhere to a federal law, risk losing her license? She agreed to meet us at the Heritage for an interview. You said you show most of the properties here. To the best of your knowledge, have you ever discriminated based on a person's race as to whether or not they can live here?
Anybody can live at the Heritage. We have no discrimination of any kind in the building.
She denied ever talking about race with potential buyers, even after I told her about our investigation. We've had several people come to us and say that you say that this is not a mixed community, that it's only white people are allowed to live here.
No, I've never made that statement to anyone. I would certainly lose my license if I did a thing like that. We do not have a mixed neighborhood here. But I've never made a statement like that.
Busted.
So here's what's happened as a result of our investigation. Today, Ann Bryant submitted this letter to her employer. She's retiring from real estate effective immediately. To remind her agents, their agents, of the importance of this issue, her former employer is requiring each agent to sign a second ethics policy. Also, I've spoken with the president of the Heritage Homeowners Association. His comments: we don't discriminate in any way at all on the issue of why Bryant has been on hand almost every time a prospective buyer looks at a condo for sale in the building. The president said, quote, she is not authorized by the board to show property. After viewing our tape, HUD opened its own investigation. HUD officials have told us their attorneys will be able to make a decision based on the possible violation of federal law very soon. And of course, J.R. and Darcy will keep you posted.
Well, Johnny, has this realtor had any past incidents?
We found out today, yes, she has. In 1997, a couple filed a claim against Bryant's former employer, naming her and her realtor as accusing her of steering. That's a practice referred to right here in the Fair Housing Act. Protected class, what type of housing or location would or would not be appropriate for them, steering them in that direction. Her employer settled that claim, and Bryant had to pay a fine for that offense. So certainly a lot coming out of this story still to come, and we're going to continue to follow it in the next couple of days.
All right, Johnny, thank you.
Sure.
Well, we also contacted the State Realtors Association after our investigation of the Heritage, and this is how they responded to what we uncovered. Realtors adhere to a high standard of integrity and a code of ethics that requires equal access to fair and affordable housing for all, regardless of race, color, religion, sex, handicap, or national origin. They go on to say, as realtors, we deplore and will actively pursue action against any member whose actions run contrary to the federal or state fair housing laws or the Realtor Code of Ethics.
Well, we would like to get your feedback on our investigation of the Heritage. There are two ways you can voice your opinion. You can call us at 647-0299, or you can log on to our website at WLTX.com and click on the viewer.
I'm allowing this to play through because we're also going to see what the outcome was.
Voice section. We'll share more on this investigation, including some of the comments we received tonight, with you tomorrow during our 6 o'clock newscast.
So look at this. In 2005, HUD launched an investigation and reached a settlement with her broker, Century 21 Bob Capes Realtors. Bryant had to give up her real estate license, and then she died last year. So for those who are thinking that she would get away with it, because she just turned in her license, well, then they took it away and she died. So yeah, she's not working in the business no more. But Jared Glover, a black public relations specialist for the city of Columbia, South Carolina, that was that news guy, Chappell's roommate. That was his black friend. That was his college roommate. He sent him in undercover at one point as well. So at that time, so he experienced Bryant's comments as well. So he filed a lawsuit, a housing discrimination lawsuit in federal court after she's dead already, that ended in a settlement with her broker awarding him $90,000. Remember, I was telling you guys that your broker can be held liable. Your broker's responsible for everything that you do. They're responsible for making sure that you follow the laws and that you follow the rules, and they could be held just as liable. What do we call that? When your broker can be held just as liable for what you do when they take no action to stop or prevent any illegal activities that you're engaging in. They call it guilty knowledge. Remember that? Guilty knowledge? So because of guilty knowledge, her broker had to end up paying $90,000. She's already dead. And as a result, his brokerage now also has to provide fair housing training for all of their employees. Okay, so that's an interesting story there, don't you think? It showed you pretty much from the start of the transaction through to when she died, and then there was a resulting lawsuits and award settlements when the lady's not even alive anymore against her broker. So it also brought up the fact of the broker having to be aware of what their agents are doing and taking actions. And the broker whether they're aware of it or not, should they been aware, especially since she has a history, right? She has a history of discrimination. The broker should have been aware of this. All right, so the federal laws are the Civil Rights Act of 1866 and the Federal Housing Act of 1968. HUD enforces the federal anti-discriminatory laws, and you have 1 year to file a complaint and have the charges heard by an administrative judge within HUD itself. Or if you want to make a federal case out of it, you could have it heard in federal court, and you have 2 years to have it heard in court. Now, there's something called an injunction on page 73 that we're actually going to highlight this at some point here. Let me see where we are here. I'll show you a screenshot of it at some point. We need to know what this term injunction means. It will be on your state exam, most likely. It's when a judge orders somebody to do something or to refrain from doing something. That's what an injunction is. To take action or to stop taking action. All right. The LAD, now we're going to start learning about the New Jersey Law Against Discrimination. For short, the abbreviation is LAD. All real estate is covered by the LAD, residential and commercial. It does not cover personal property like the Civil Rights Act of 1866 did. What is the Fair Housing Act of 1968? What kind of property does that cover? There's a hint in the name.
Residential.
Residential property only. Civil Rights Act of 1866 covers all property, real and personal. Fair Housing Act covers residential only. And the New Jersey LAD covers all real estate. So both residential and commercial. And complaints that are made to and enforced by the State Attorney General's office. You have 6 months to file the complaint, 180 days, 6 months to file the complaint. Those who interfere with an investigation can be found guilty of they can be given a fine of up to $500 and 1 year in prison. And the Attorney General's memorandum is a disclosure about the New Jersey Law Against Discrimination and the federal laws, telling people that you put your property on the market, whether you hire a real estate agent or not, you need to follow the state and federal laws. So that's why we need to give it to property owners, telling them that they cannot discriminate when selling or leasing residential and commercial property. And we need to give that to the owners at the time of listing. And you, the real estate licensee, must refuse to take listings when a property owner indicates that they have an intent to discriminate. All right, a lot to unpack in there. What kind of property does the LAD cover?
But what if they like a brokerage company doesn't speak English, like they speak Spanish only? Is that discrimination?
Well, who are they speaking to? I mean,
well, prospect, if prospects are calling, they're like, sorry, I cannot speak English. It's only Spanish.
What, if buyers are calling, you mean?
Yeah.
And they have nobody there that speaks English?
Yeah, they only handle the, if it so happened a couple of times calling, they only speak Spanish. Is that discrimination?
You know what? I would imagine they got to have somebody there that speaks English. I mean, even the broker, you got to talk to the real estate commission at some point. You got to talk to somebody, but is that discrimination? Did they not show you a property or something? I know you can't communicate, but I guess you can. You could pull up a translation app on your cell phone, Is it discrimination in itself because they don't speak the language? No. Discrimination is an act where they that negatively affects you because of a certain reason. whether it's your race or country that you come from or something like that. I wouldn't consider that discrimination that they don't speak the language. I just find that really odd. How do you do business? You know, if nobody there speaks other English, you know.
Yeah, Perth Amboy. That's what happened.
Yeah, I know in Perth Amboy, there's a lot of brokerages. You got a huge Spanish population, but I can't imagine that the broker doesn't even speak English. Yeah.
Well, broke around, and you have somebody who just speaks Spanish.
Yeah. Yeah, you may have trouble communicating, but there's ways around it. You can bring up the app, okay? So licensees, though, yeah, that's a weird scenario.
Okay, we can.
But no, I wouldn't consider just not being able to speak the language discrimination. No. State allows it, right? So, what kind of property again does the LAD cover? The law against discrimination. It's right in front of you guys.
What did you say?
What kind of property does the New Jersey law against discrimination cover?
Residential and commercial.
So all real property, residential and commercial. Yeah. And how long do you have to file a complaint for violations of discrimination under the New Jersey law against discrimination?
6 months.
6 months, 180 days, right? What is the document that we need to give owners at the time we get a listing? What's that document we got to give to property owners when we go to get a listing that tells the property owner, informs them that whether they hire us or not, they can't discriminate when they put their property on the market for sale or rent? It's an exam question, so.
Is it listing agreement? No.
It's the Attorney General's memorandum. Okay, so as you can see right here, if you can see my mouse, the Attorney General's memorandum. The Attorney General is the highest law enforcement officer in the state, and a memorandum is a fancy word for a notice. So the Attorney General's memorandum is that disclosure about the New Jersey laws and the federal laws against discrimination that we need to give to property owners at the time we get a listing. That's going to be an exam question all on its own. What document did we give to property owners? What do we need to give to property owners at the time of a listing? Now, you're going to have multiple choice options. And I guarantee you, in those multiple choice options, one of the answers will be the correct answer, the Attorney General's memorandum. Another one will be the New Jersey law against discrimination, or they could just say the NJ LAD. And that would be incorrect. You're not giving people the law. You're giving them the document that talks about the law. You guys follow? I'm trying to make that clear because I know when I was in your position studying for my exam, taking my notes, I remember having my notes and I'm looking at my notes and I'm seeing the Attorney General's memorandum and the New Jersey law against discrimination. I'm like, they look like they're the same thing. What's the difference? Well, the difference is that it's just as simple. A memorandum is a notice from the Attorney General about the law. You don't give people the law, you give them the notice about the law. You got it? And what do you do when somebody tells you that they intend to discriminate? Refuse the listing. Turn down the listing. You don't take it. You don't try to explain to them that discrimination is wrong, and then if they change their mind, be like, okay, cool, I got the listing. Because the odds are that if somebody's discriminating now at the beginning and they're saying that, and then you try giving them an explanation and they're like, oh, okay, but yet they really have discrimination in their heart, by the time you get that property listed, they're probably going to be discriminating again. And if they do, now they're putting your license on the line. you know, so you're better off just not dealing with those people. All right, so that LAD has been updated. I'm sorry, the LAD. The Attorney General's memorandum has been updated to include the Fair Chance in Housing Act. All right. We're going to be actually going over that in the next couple of slides. We're going to be going over these, what you see in the book too, for the Attorney General's memorandum. Now, for the violations of the LAD, the New Jersey Law Against Discrimination, there are fines that you need to know. You need to memorize. It's up to $10,000 for a first offense, up to $25,000 for a second violation, and up to $50,000 for further infractions. So 10, 25, 50, 10, 25, 50, up to 10, 25, 50,000. Those are the penalties. Now, I know I didn't go over with you what the penalties were for violations of the federal anti-discriminatory laws, because it's not going to be on an exam. It's such oddball numbers for you to try to memorize that they're not going to give it to you. Yeah, I'll show it to you. Well, it's right here on this slide. You see this? For violating the federal anti-discriminatory laws, for a first violation, it's $21,663 for a first offense, $54,157 for a second offense, and $108,350. Where do they come up with these obscure numbers? First of all, and how would they expect you to memorize it? They wouldn't. However, you do need to memorize 10, 25, and 50. A lot easier to remember that one, right? So you'll need to know that violations, what the penalties are for violating the New Jersey Law Against Discrimination. All right. So let's do these highlights about who investigates violations under the federal laws, HUD. And here's where you would highlight what an injunction is. Injunction is when a judge orders the offender to take action or refrain from taking action. So a judge could force somebody to rent, a landlord to rent to a tenant that they previously denied. Or he could order them to stop harassing them. Everybody got this?
Yes.
Yes.
Okay. Huh. Hold on. We're missing a slide here. Oh, wait, no, we already highlighted that from Fair Chance in Housing Act 2021. Okay, no, it's the same thing there. I just didn't update it. It says 2021 now. And all the wording is still the same. Let me just make a note to get a newer screenshot in there on this slide. Sorry. I do the 46. Three. Sorry about that. Now, in case you didn't know, you can't use threats or acts of violence to get somebody to rent somewhere, or for a landlord to rent to somebody, or for somebody to move or anything like that. If you do come across somebody who's using threats or acts of violence to try to intimidate somebody, report it to your local FBI or police department. All right, so the New Jersey lad, here are the protected classes. A lot more than the 7 protected classes under federal law. We have race, color, national origin, ancestry, nationality, sex, gender identity or expression, affectional or sexual orientation, marital status, civil union status or domestic partner status, familial status, pregnancy or breastfeeding, actual or perceived mental or physical disability, actual or perceived mental or physical disability, including AIDS, HIV, COVID-19, you pick the disease, you know. Source of lawful income used for mortgage or rental payments, including Section 8 housing choice vouchers, state rental assistance programs, TRA, that's temporary rental assistance that usually comes from Catholic and Jewish charities here in New Jersey, and liability for services in the armed forces of the United States. How bad has it gotten when we need to make our members of our military a protected class because they would be discriminated against by someone here? What is this, Vietnam all over again, where they soldiers come back to and you spit in their face? It's also illegal to place on any advertisement or make any statements or utterances that express directly or indirectly any limitation to offer housing or real estate based on any of those characteristics. Technically, under the Fair Chance in Housing Act, ex-convicts, they now refer to them as system-involved people. I didn't make this up. You'll see it. You'll see it yourself. They actually renamed ex-cons because it's a negative stigma to that name, ex-convict. Well, hold on a second. You were convicted of a crime. When you're in prison, you're convicted. You're a convict. When you're out, you're an ex-con. Okay. Now they renamed them to something softer. You're a system-involved person, whatever the hell that means. And you're considered a protected class now in New Jersey. Wow. See, those who control the speech, right?
That's ridiculous.
That's like what I remember like years ago. They tried classing up the garbage man. They changed the job title from garbage man to sanitation engineer. Yeah.
I mean, that one I'm okay with, but the convicts.
Yeah, I know, but this is just an example of how they try to change the speech a little bit for some of these things. But this one, yeah, come on, man. You're a convict. You know, why are we calling you system involved? What the hell does that mean, system involved? Does that mean that you're a guard in a prison? You're involved in the system? What is that saying? You know, system involved.
Should be criminal system abuser type of thing.
Yeah. Ex-criminal, ex-convict. You were convicted of a crime, and now you're no longer convicted because you served your time. You're an ex-con. Anyway, you don't need to study this guide over here, but this is a guide about which laws cover what protected classes. It's probably easier to read just the notes that I gave before instead of trying to study this thing. All right, so page 75, New Jersey law against discrimination forbids refusing to sell, rent, lease, assign, or sublet as a means of discrimination. For you, the real estate licensee, refusing to offer property or to negotiate transactions as a means of discrimination, or lying about the availability of property to someone because you want to discriminate. Changing the terms of real estate transactions or offering special facilities or services to any person as a means of discrimination, or being involved with any expression directly or indirectly of any limitation based on discrimination. This includes statements, advertisements, publications, signs, rent applications, purchase offers, and records of inquiries. Exceptions would be New Jersey law only has one exception. It allows rooms, apartments, or flats in certain types of housing to be restricted to members of the same sex. Yeah, like college dorms, or religious-based organizations to discriminate on the basis of religion. An owner-occupant to discriminate except for race on the rental of a duplex. That's a two-family house. Duplex is two-family house. The units are side by side, one next to each other, or an over-under where the one unit is above the other. Note that these exemptions are similar to those under the federal fair housing law. New Jersey law, however, does not contain the federal exemption for homeowners selling their own homes when a broker is involved. There's never an exception for race when a broker is or is not involved. Here are which laws cover what types of property. This is an easier guide. Civil Rights Act of 1866 covers all property, personal and real. That includes residential and commercial, as well as your personal property, like the clothes on your back. Fair Housing Act of 1968 only covers residential property, has nothing to do with commercial or personal. And the LAD, the New Jersey Law Against Discrimination, covers all real estate, residential, commercial, but not personal. So there you go. Boom. At a glance. If you want to snap a picture, get a screenshot to study which laws cover what property. All right. Blockbusting. If you get 3 or more listings on a road, you need to keep records about how you got those listings, what kind of solicitation you did. Were you doing door knocking, walking door to door, knocking on people's doors? Were you sending mailings out? Were you calling up? And what kind of phone script were you using? What script were you using? What did you say to these people that you were able to get these listings? The purpose of this is to be able to investigate and see if there was any blockbusting involved. If you have 3 or more listings on a block there or one street, you're required to keep records of that solicitation that you used to get those listings for 1 year. And New Jersey has its own equal housing opportunity poster as well. And failure to display that poster does not make you automatically guilty of discrimination. It is just punishable by a fine of $100 or more. Everybody got that?
Can I get like 2 more minutes?
Sure.
Okay, I'm good. Thank you.
All right. Here is New Jersey's poster. That's what it looks like. No equal house in there or anything. New Jersey has a lot of posters, though. Our Division of Civil Rights, njcivilrights.gov, it seems like they got nothing better to do than to look for potential problems or even create potential discrimination scenarios, where ones I've never even heard of before, where they come up with ideas for them, and then they have seminars and all kinds of things, The latest thing that they've, one of the newer things that they've come out with is that appraisals are racist now. So, which is kind of funny because you get people that if the appraiser doesn't appraise it for a high enough price, they don't get the money to buy the house. And then later on, when they own the house, the appraiser's over appraising it. Now we got to pay too much in taxes. You know, that appraiser is damned if they do, damned if they don't. But the funny thing is, once we get into appraising and valuing property, they have to have it supportable evidence that justifies their valuation. It can't just be based off of an appraiser's, well, you know what? I want to jack the property value up on you because I'm racist, you know. You can't do that because it has to be based on supportable evidence, which we call comps, comparable properties, to justify that valuation, which that blows my mind then that they're talking about, you know, that appraisals by appraisers can be racist. I don't know. They've actually had seminars on it. I went to the seminar and they couldn't cite any examples in New Jersey. They were citing some examples somewhere else, but it was like really off the wall stuff. It was way out of the norm of what an appraisal is, you know, or what an appraiser does. It was more like arguments that they were having with people. So this New Jersey Division of Civil Rights, it's kind of interesting, the kinds of things that they get into. I actually have in my browser window, let me see. Let me look up my, I just saved a bunch of, I stumbled across them the other day and came across a bunch of posters that this Division of Civil Rights, here we go. Division of Civil Rights came out with. Okay, so here, I'll share it with you in the window here. Emotional support animals. Here they go. 5 things you should know about emotional support animals and in housing. All right. You guys want to see these posters? I could share them with you in the chat window there. I just came across these the other day. These ones are not in the ClassLinks Word document yet. There's that one for the service animals. What else they got? Division of Civil Rights posters. Protections from discrimination or harassment in employment based on gender identity or expression. A lot of this stuff is for dealing with transsexuals and things of that nature. But check out this one. There's also this one here. If somebody wants to be called ma'am, but they're a Mr. or vice versa, this is this deals with that as well. It actually makes it a crime. I understand being polite to people and all that stuff, but you know, I can't foresee forcing people to censor their speech. You look like a guy, they call you a Mister. How are you going to hold that criminally against somebody? I understand being polite and all that, but expression of free speech, which this country is based off of, should not be under a law like that with criminal penalties and civil actions against people. But anyway, there's that one. What else did they have here? Fact sheets. Protections from discrimination on harassment in housing based on your source of lawful income. Okay, this is one that we deal with. You cannot discriminate on someone based on their source of lawful income if they're getting Section 8 housing benefits or benefits from any other governmental program. You could only discriminate, and it's not really discrimination, but you could only discriminate based on their non-lawful source of income. Like if they're dealing drugs or in prostitution or things of that nature, human trafficking or things of that nature. You can only judge their lawful source of lawful income when renting to somebody. Let's see, housing fact sheet. What is this? Protection against discrimination on bias-based harassment. Here's another one that we should go over. This is basically sexual harassment against tenants. These links I should probably put into the slideshow coming up when we get to the rental chapters, but that's not till chapter 12. And then what else do we have? Let's see, I think they got another one here. Civil rights posters. Okay, and then here's just the general New Jersey Housing Resource Center. Rental assistance. Oh, I know. Okay, that's not posters. Okay, I was looking for the poster stuff. Okay, so that's it for the posters I'm sharing there with you. Okay, so this one, New Jersey Law Against Discrimination, is also there somewhere on their website. This needs to be posted in your office as well, right next to that Equal Housing Opportunity poster. Now, enforcement of the New Jersey Law Against Discrimination. Who's the highest law enforcement officer in New Jersey? What's that position called? Come on, guys. I told you this like 50 times already. The Attorney General. The Attorney General. So complaints brought under the New Jersey Law Against Discrimination must be filed with the state's Attorney General within 180 days. Okay. So I have the one slide with all these notes on it now. Now you're just highlighting these notes in the book here on page 78. So get them. And the one we didn't go over yet is Fair Chance in Housing Act. If you violate that law, it's up to $1,000 fine for a first violation and up to $5,000 for a second and up to $10,000 for 2 or more violations. I would imagine that's possible that could be on exams. I do not know, but I would imagine that it could be. In addition to violating the LAD, violating the law that makes criminals a protected class, you get fines too. 1, 5, and 10,000. Just let me know when you guys have that. Oh, and I'll also throw out the after lunch attendance poll. Boom.
I got it.
Okay, everybody got the highlights on the notes here?
Got it.
Yeah, got it.
And this is a continuation of those notes that we need to give that Attorney General's memorandum to the property owner at the time it's listed. And we must refuse listings from those who tell us that they have an intent to violate the LAD, the law against discrimination.
I got it.
Okay. All right, so here is the Attorney General's memorandum with that Fair Chance in Housing Act addendum to it that was added. So this is the latest version of the Attorney General's memorandum here. We're going to look over the actual document. As you can see, it's got the Great Seal of New Jersey here at the top, coming from the Office of the Attorney General, Department of Law and Public Safety, Division of Civil Rights. It looks like an email, right, to property owners from the Attorney General, the date, and the subject is housing discrimination laws. So this is the document that we need to give to property owners at the time we get a listing. The New Jersey Real Estate Commission, the REC for short, requires every licensed broker or salespeople with whom you list your property to give you a copy of this notice. And the purpose is to help you comply with the LAD and the Fair Chance in Housing Act, that newer law that they made effective January 2022. Now, under the LAD, it's illegal to discriminate against prospective or current buyers or tenants because of their protected class. And then they just drill through the protected classes here again. It's also illegal to make any print or publish any statements, including print advertisements and online postings, expressing any preference, limitation, or discrimination on any of those protected characteristics. So the LAD applies to a wide range of activities, such as advertising, selling, renting, leasing, subletting, assigning, and showing property, including open land. And here's some issues that often come up. See, in previous versions of the LAD years and years ago, previous versions of the LAD, they never had the examples. They never cited examples. We as the real estate agents would always have to interpret the law for the people that we're working with, the buyers, our clients and customers. So I like when they started changing it years ago and they put actual examples in there, it made it a little bit easier for us to point it out to these people in the public, because previously they would give us pushback. When we are trying to interpret the law, they tell us, yeah, you'll say anything you want. You just want to earn a commission, you know? So let's take a look at it. The prohibition on discrimination based on source of lawful income means, for example, that a landlord cannot reject a prospective tenant because they intend to pay with subsidies or vouchers provided by the federal, state, or local rental assistance programs, including Section 8 housing choice vouchers, COVID-19 emergency rental assistance programs, state rental assistance programs, temporary rental assistance, eviction prevention program that was during COVID, unemployment benefits, child support, alimony, and supplemental security income. These are all lawful sources of income. A housing provider cannot advertise a property in any way that discriminates based on source of lawful income, including by posting advertisements that state directly or indirectly that you don't accept or express any limitation on vouchers or subsidies. For example, advertisements that state no Section 8 or TRA not accepted, or this property is not approved for Section 8, because to collect Section 8 benefits, the property needs to be examined by one of their inspectors. But I tell you what, it's not hard to get it approved for Section 8. Their standards are not that stringent. Okay, so posting something like that is just a way to try to intimidate somebody and chase them off. In addition, housing providers must calculate any minimum income requirement, financial standard, or income standards based only on the portion of the rent that's to be paid by the tenant, and not the entire rent, which is being partially subsidized in part or in whole. The LAD prohibits bias-based harassment in housing, that's sexual harassment. If a tenant is being subjected to bias-based harassment, that creates a hostile environment. And if the housing provider knew or should have known about it, the housing provider must take reasonable steps to stop it. Yeah, now we got to play a babysitter. If you're a landlord, you got to be the babysitter of your tenants. Hey, stop harassing the other tenant, and take action against them. But it may not be so easy to take action against them. Remember, we can't do those criminal background checks. We can't deny people rentals because of certain reasonings, that could try to protect them in advance. We can't take those precautions in advance. So now once you got the tenant in there, it's not so easy to get them out, even if they're harassing another tenant. But yet the landlord's still responsible for that. So that puts them in a bit of a predicament because the way the laws were drawn up now. This includes harassment by other tenants and by a housing provider's agents or employees. A quid pro quo. Anybody ever hear that term, quid pro quo? This is sexual harassment in exchange for you doing a favor for your tenant or doing something you're supposed to be doing in exchange for sex or sexual favors as a condition for maybe making necessary repairs or helping a tenant apply for their Section 8 benefits or something to that nature. Here's an example in Elizabeth where a landlord did that. Here's a bunch of buildings that this one landlord owns, along with all of these other buildings. Federal authorities have filed a suit against this guy, and this is in 2020. I saw this on New Jersey 1015 website. That's the radio station for New Jersey. They talk about all kinds of New Jersey issues. So I looked at this. I figured this would be a good example to show, especially since I know somebody that lives in this building. And that girl was always like, oh, I keep getting trapped in the hallway by the landlord. He's such a freaking perv. He wouldn't let me go. And now I know. So the federal authorities have filed a lawsuit accusing the landlord who rented to low-income residents of sex from residents on multiple occasions. The sexual harassment complaint filed by the Department of Justice in the U.S. District Court in Newark named Joseph Santani, who authorities said owns numerous properties in and around the city of Elizabeth, ranging in size from 4 to 100 units. Santani receives about $102,000 every month from the Federal Housing Choice Voucher Program, or Section 8. How up do you got to be that you got to harass tenants for sex? I mean, come on, dude. You're getting $102,000 a month in payments just from these programs, let alone the regular rents that the other tenants pay in the other apartments. Man, is your play that bad that you need to sexually harass tenants? Come on. What is this? The lawsuit alleges that since at least 2005 until last year, what happened? There we go. The lawsuit alleges that since at least 2005 until last year, Santani engaged in severe or pervasive sexual harassment that included demanding oral sex in exchange for helping residents stay in their housing and receive assistance. Authorities also allege that he threatened to evict tenants who rejected his advances and also demanded sexual favors from prospective tenants. What a scumbag. Can you imagine a place that you're considering moving to? You don't live there. You're just checking out the place and the guy's already sexually harassing you. What a pain on this guy, huh? Oh my God. You know what? I actually think I met this guy. I think I did meet this guy about selling one of the properties that he did own in Elizabeth years ago. I got to check my records because that name seems very, very familiar. The guy didn't seem like a bad guy to me. He seemed like a really nice guy, older guy, or presentable, but I guess he's a scumbag, huh? Let's see. How about this? Here's another situation. While it's disgusting and understandable to be uncomfortable living there, knowing things like this are happening, If a landlord's employee enters your apartment and masturbates in your fiance's panties, does it constitute a crime of sexual harassment? What do you think? Is that a crime?
Yeah, it's a crime.
The guy came into your apartment, you were not home, and he goes through your fiance's underwear drawer and starts playing with himself in their panties there. What crime was violated? That's sexual harassment?
He's like a pedophile. I don't know. It's kind of weird.
Well, pedophile is when you're
Oh,
messing
you
with.
know this guy? Do you know this guy, Victor?
I don't know this guy.
Okay, never mind.
Okay. Here's a news story on it.
Top story tonight, a Hoboken couple says their privacy was violated. Their bedroom security camera caught a maintenance worker going through their things.
But it's what they touched that has them still uneasy. News 12 New Jersey's Erica Such joining us in the newsroom with more on this story. Erica.
The couple tells us they purchased this security camera to just watch out when anyone was in their apartment, but never expected to capture an employee of their building going through their underwear. Take a look.
It said there was a notification for motion, so I checked it.
The Rivington resident Alex Sacchetti says he was at work just a few weeks ago when his security camera in his bedroom captured moments a maintenance worker did something out of the ordinary.
I started watching, and the man was, going towards the dresser. I was like, wow, that's strange. And then he opened it. He was going through my fiance's underwear. And, after I watched the entire event, there was potentially other lewd acts that took place, but mainly just going through my entire apartment.
The worker is seen checking the bedroom door, closing it, and turning off the lights before going into the corner of the room, blocked by pillows on the camera. Sacchetti says he quickly called management and alerted them. That's when this moment shows the man looking at the camera when he answers his radio call to leave the unit.
It was pretty much your whole privacy is violated.
Sacchetti says his fiance has been so upset by the situation, she's staying elsewhere for now. They filed a report with Hoboken police, but were told this.
He had the right to be in here, and apparently anything that took place is not a crime.
The two have been back and forth with Equity Apartments, who owns the complex, but says their responses have been lacking empathy.
There's been some outreach from some sort of manager or something, I'm not exactly sure. But as far as oversight or, hey, so sorry this happened to you, none of that.
And while this
guy is so wishy-washy, I would be screaming at the police. I wouldn't take that line down that the cops say, oh, they didn't do anything wrong, they're allowed to be in there. Really? I thought that supervising that maintenance personnel and such, they're not allowed to use the access key just to enter the apartment unless they got the tenant's permission or they gave advance notice that they were going to be there because they were maybe exterminating or doing some sort of an inspection for something, right? It had to be arranged in advance. You can't just use your pass key because you're the landlord to walk into the tenant's apartment at any given time, can you? You can't. So this guy's just taking it, oh, well, they said, So in the meantime, now his fiance moved out and he's still there. It's dude, you need to be more forceful. So anyway, nothing happened to them here.
Situation still leaves him uneasy. Sacchetti says it's a warning for others.
People here or elsewhere that have buildings should just have some sort of surveillance to fall back on.
And the couple tells us they're hoping to switch apartments in the near future. We did reach out to Equity Apartments for comment, but did not hear back. In the newsroom, Erica Such, News 12, New Jersey.
Wow. Has the landlord's employee sexually harassed anyone? I mean, nobody was home. I mean, it's disgusting what he did. But did he sexually harass anybody if nobody was there? No, he didn't. But did he have the legal right to enter the apartment? I would argue no, he didn't. He was breaking and entering. Even though he had the key, he didn't have the permission to be in there. Can a landlord enter an apartment without the permission of the tenant? No, they can only enter without prior permission in the case of emergencies like gas leaks, floods. Otherwise, they're breaking and entering. And this could have they could have put criminal charges against them. But the police were like, yeah, they have the legal right to be there. You know, I would have pushed to speak to a higher up, to a supervisor. And if that tenant, it looks like that's a big building. If that tenant read their truth in renting booklet that the landlord was required to give them by law, they would have seen that there's something that covers this issue. It's called a trespass. A trespass complaint may be filed by the tenant with the local police department under the New Jersey Criminal Code for what's called defiant trespass under New Jersey Statutes 2A 39-6. So if we were to actually, here is a link to the Truth in Renting booklet. I'll share this link with everybody. Landlords are required to give this to you if it's a building with 3 or more rental units, not counting the unit the landlord lives in. However, the laws in this booklet apply to everybody. So, come on. So this is the Truth in Renting booklet that I just shared the link with. And it covers a whole host of issues. And one of them you can see is right of entry, page 11. Covers all kinds of stuff, rents, the habitability of the place, eviction, covers all kinds of stuff. So let's go down, what was it, section 11 or page 11? Right of entry, here we go. In general, a landlord does not have the right to enter a residential rental premises without the consent of the tenant or a judgment from the Superior Court. In a written lease, the landlord's duty not to enter the premises is called the covenant of quiet enjoyment. That's one. When a landlord, what is a lease? A lease is when it's a document that states that the landlord is going to turn over the physical premises to a tenant who is going to rent to them, along with all of the rights that the owner of the property has. They're going to turn over all those rights to a tenant for a limited period of time as defined in the lease, except for the right to sell the property, to mortgage it, to give it away, you know. So a landlord shall be guilty of unlawful entry and detainer if they enter a rental premises peacefully or forcefully and then detain and keep possession of a property. Okay, that's not what we're talking about here. It's a complaint, unlawful entry and detainer. There we go. If a landlord enters a rental premises unlawfully, a trespass complaint may be filed by the tenant with the local police department under the New Jersey Criminal Code for defiant trespass. That's exactly what what their service people did. So a tenant or landlord, depending on the judge's decision, shall be entitled to possession of real property and shall recover damage. Okay, they're going into some other stuff now. But here's where it's them just entering your apartment without the permission. Yeah, they did violate the tenant's rights. They broke in. It's breaking and entry. It's a crime. But sexual harassment, did that occur? No. Even no matter how disgusting you think it is that what he did, it is not sexual harassment because nobody was there to be harassed. All right, so housing providers must reasonably accommodate tenants with disabilities, unless doing so would be an undue burden on their operation. For example, if a tenant shows that they have a disability and that keeping an emotional support animal would be necessary to afford them an equal opportunity to use and enjoy the dwelling, the housing provider must permit the emotional support animal, even despite a no pets policy, unless they could show that doing so would be an undue burden somehow. Consult with an attorney. A no pets rule cannot be enforced against a person with a disability who has a service or guide dog. And landlords may also not charge a tenant with a disability an extra fee for keeping that service or guide animal. Landlords must permit tenants with disabilities the tenant's own expense to make reasonable modifications to the premises if such modifications are needed to give the tenant an equal opportunity to use and enjoy the dwelling. Like if they needed to put a wider door in to accommodate a wheelchair, or to put ramping in, or make some other modification of that nature. The law prohibits, let me ask you a question. If the law requires the landlord to allow them, the tenant, to make those modifications, who has to pay for those modifications?
The tenant?
The tenant at their own expense. Now, when the tenant moves out, do they got to put it back the way that it was? Come on, we're just giving ideas. There's no right or wrong answer. Well, there is a right or wrong answer, but don't worry about it. This is the place where we're just having a discussion here. Don't worry about being in.
Maybe yes.
Huh?
Maybe yes.
It depends. What does it depend on? Is that modification that was done going to cause a burden or hardship on the next tenants? If it would, then yeah, they would have to put it back. Like any ramping that they put in, yeah, they should have to remove that. But replacing a wider door by putting the narrow door back in, no. Actually, future tenants would love that, because why would future tenants love that? Having a wider door at the front door. Easier to move your furniture in and out. You know, moving that furniture through that door, we're trying to figure out how does that couch get in there. Yeah, been there. All right, so the law prohibits discrimination based on familial status. For example, discrimination against families with children under the age of 18 and pregnant people. Oh my gosh, I had an issue with this before. This bullet point was not on there on the old versions of the LAD. When I was showing a property, it was a condo in, where the hell was that? Roselle Park? Yeah, I think it was Roselle Park. It was a condo in Roselle Park. I had to meet with the landlord because there was no lockbox or what have you. So the landlord let us in. My clients were the renters. They were planning on buying sometime in the future, but in the meantime, they were just going to rent while they could save up money for their expanding family. They already had 2 little children, and one was clearly on the way. She was pregnant. So we meet with the landlord. Opens the door. I say, after you guys, and they go in, and then the landlord grabs me by the arm and he says, "I'm not renting to them." I was like, so I pulled him to the side. I was like, what are you talking about? He's like, "I'm not renting to them. I'm not going to get in trouble." I'm like, "Why would you get in trouble?" He's like, "Did you see her belly? She's going to pop any day now." I was like, "Dude, what are you talking about?" I was like, "Lower your voice." He's like, "I'm not going to get in trouble for renting to too many people." I was like, "Why would you get in trouble?" Well, because Roselle Park has an ordinance, no more than 2 occupants per bedroom, and there's already 4 of them. And she's going to pop in trouble for renting to too many people. I was like, "Well, first of all, that baby is not here yet. She's pregnant." I'm like, "You're not going to get in trouble for renting to someone who's pregnant that then has a baby." Can you imagine the scandal of that and how that would sound in the press if somebody were to file a complaint about that? And he was like, "Oh, you can say anything you want. You just want to earn a commission." And I was like, "Listen, okay, I'm going to stop right here. You better talk to your agent and your attorney before you say another word. Because if you deny, if my clients are interested in renting this property and you don't turn them down because of what you just said, you're going to get slapped with a discrimination lawsuit so fast it's going to make your head spin." So I would bite my lip before you say anything else. And then we went in. And my clients were interested in renting. So this guy did check with his attorney, because I said, "Okay, well, we're going to put together a lease, and I'll put it together and I'll send it over to you." And he checked with his attorney, and his attorney confirmed what I said. First of all, that child's not here yet. It wasn't born. so you can't consider them an occupant. And even when the child is born, an infant cannot be considered an occupant until they reach 24 months of age, 2 years. So as long as those tenants know that after the baby's born, they could only be there for another 2 years before they got to move out. They're okay with that, then that's fine. And my clients were okay with that, so they rented. But wow, can you imagine somebody talking to you like that? I'm not renting to them. You see her belly, she's going to pop any day now. First of all, I never heard anybody use that expression before for a pregnant person, you know. That was crazy. That was crazy. It really threw me off, threw me back a little bit. But then when I started explaining to the guy, and then he's like, well, you're going to say anything you want, you know, you just want to earn a commission. I wish that this version of the LAD had this spelled out on it. But back then it did not have any examples of anything. We just needed to interpret the law for our clients. Now it has, this is the actual LAD we're going over. I'm sorry, the actual Attorney General's memorandum that we're going over. So I wish the Attorney General's memorandum in the past had these examples on it, because God knows I could have used it to explain it and show the people. All right, so next, selectively inquiring about or requesting information about a documentation of a prospective tenant's or buyer's immigration or citizenship status. Well, first of all, that doesn't even matter anymore in New Jersey, because New Jersey waved the magic wand. Our governor waved his magic wand and convinced the politicians to make us a sanctuary state. I don't know how that's even legal. How states can pass laws that are contradictory to federal law. Well, they could do it until the feds decide they want to come here and enforce federal law. Okay. And we're seeing that actually happening right now too. But we are a sanctuary state, New Jersey, but irrelevant of that, even before that, you can't just look at somebody and assume that they're not, they may not be here legally because they look like they're a foreigner, and ask them to prove their citizenship status. Look, we're a melting pot here. We got people from all over the world. They become citizens and they live here. You can't assume because the way somebody looks that they're not a U.S. citizen, all right? And demand that they, papers, please? You can't demand that, you know? That would be discriminatory. So, yeah, you can't do that. Because you assume their citizenship status because of the person's actual or perceived national origin, race, ethnicity, or otherwise discriminating on that basis. That's a violation of the New Jersey law against discrimination. And as explained, here's that one that Obama's guy passed there, you know, about criminal justice system being racist because there's not an equal number of people in prison based on their color of their skin. So therefore the criminal justice system is racist. And so based on that guidance document that guy wrote, you cannot use people's criminal history against them, apparently, when they rent, because that violates the LAD and the Federal Fair Housing Act, because they have disparate impact based on, oh, look at that. They passed it based on the federal law too. Disparate impact based on race and national origin, and are not supported by legitimate business necessity. Yeah, says you. Ooh. And housing providers may not use criminal history as a pretext for intentionally discriminating based on race or national origin. Yeah, if you can do criminal background checks, you do them equally to everybody. Agreed. But when you get a criminal background check and it finds out that they're a criminal, you should be able to use it against them if you don't want to rent to them. However, the law in New Jersey says you can't under certain circumstances. What are those circumstances? We're going to go over them in just a moment. So what are the penalties if you violate the Attorney General or the LAD? $10,000 for a first violation, $25,000 for a second, and $50,000 for further violations. And victims of discrimination may recover economic damages related to discrimination, like if they were to have to rent a different apartment elsewhere and pay a higher rent. Well, you could take that landlord that denied you rental and have a judge require them to pay the difference in your rent. The higher rent you have to pay now. You could also get damages for emotional distress, pain, and humiliation. In more egregious cases, a victim could also recover punitive damages. Now, this is to us. Brokers and salespeople with whom you list your property must transmit to you every written offer they receive on your property. How soon? How soon do we need to transmit every written offer we receive on a property? How soon we need to present it to the owner? It's going to be an exam question. I asked this a lot of times already. You guys should know this. All written offers need to be presented within 24 hours, guys. Brokers and salespeople are licensed by the New Jersey Real Estate Commission, and their activities are subject to the law against discrimination, as well as New Jersey real estate laws of the state. What are the laws of the state called? What are New Jersey real estate laws referred to as? New Jersey statutes or title
45:15.
Title 45, Chapter 15, correct. As well as the Commission's own rules and regulations, which we call the Administrative Code, or Title.
Can you repeat that?
So we have to follow the laws of the state, which are New Jersey statutes 45:15, but we also need to follow the Commission's own rules and regulations, which we Administrative Code or Title 11, Chapter 5.
Yeah, Chapter 5.
Okay, so the broker or salesperson must refuse your listing if you indicate an intent to discriminate. So that's another exam question. Wow, a lot of exam questions based on just a statement right there. Now, the sale or rental of property, including open land, whether it's for a business or residential purposes, is covered by the New Jersey law against discrimination because it covers both residential and commercial. All right. So let's get into that Fair Chance in Housing Act now, shall we? The FCHA, Fair Chance in Housing Act, prohibits housing providers from asking about the rental applicant's criminal records on their initial application or otherwise considering an applicant's criminal record in any way until you first made them a conditional offer to rent to them, with the exceptions of as required under federal law. So the goal of the Fair Chance in Housing Act is to ensure that formerly incarcerated and system-involved people have a fair access to housing found around the state. See, I didn't make up these terms. They actually got it written right here on the Attorney General's memorandum. Nothing about the Fair Chance in Housing Act requires landlords or housing providers to consider a person's criminal record in housing. That is a totally useless statement right there. In other words, there's nothing in the law that requires you to do a criminal background check. Yeah, I know. The point is we want to do one. So if a housing provider does review an applicant's criminal history after a conditional offer, specific restrictions apply. A housing provider must conduct an individualized analysis. Okay, so now we're worried about an individual. I thought the whole premise behind this Fair Chance in Housing Act is because a whole group of people with a certain background. Now they're talking about, well, if you want to now, you have to give them a conditional offer to rent to them. And then if you want to pull it back, well, now you have to do an individual analysis. All right. So let's do an individual analysis on their criminal record. How does that work? Well, housing providers are prohibited from asking them about their criminal records until after you first made them that housing offer. And even after a conditional offer, a housing provider may not consider arrests or charges that did not result in criminal convictions. No duh. There are expunged convictions, convictions erased through executive pardon, vacated or otherwise legally nullified convictions, juvenile adjudications of delinquency, and sealed records. Yeah, no duh. You can't use it unless they were found guilty. You can't use it against them. And if it was something that was overturned later on, or if it's something that happened when they were children, when they were kids, of course you can't use that against them. No duh. So if a housing provider chooses to consider the applicant's criminal history after a conditional offer, they could only consider these things. Are you ready? Convictions for murder, aggravated sexual assault, kidnapping, arson, human trafficking, sexual assault, endangering the welfare of a child under this particular statute. And convictions for any crime that requires lifetime state sex offender registration. Hold on, we're not done, because you see the mark there. If it was a first-degree indictable offense or a release from prison for that offense within the past 6 years. Or if it was a second or third-degree indictable offense or release for prison for that offense within the past 4 years. Do you guys know the difference between first, second, third, fourth-degree crimes? I don't. I'm not an attorney. I don't know. I couldn't tell you which one is which. Short of a law degree, I couldn't tell you which one of these people who committed murder, aggravated sexual assault, kidnapping, arson, human trafficking with this degree of a crime, and they were released for prison within certain years. You know, those are the only people that you can't, that you could say that you're not going to rent to if it happened within a certain time frame even. Or any fourth degree indictable offense or release from prison for that offense within the past year. So they're making it very difficult to figure out who it is that you can deny renting to. So for a conviction that has that can be considered, a housing provider must conduct an individualized analysis, and you have to put it in writing. Why? So that they can use it against you later. You have to consider the nature and severity of the offense. So you got to write down your thought process too. The applicant's age at the time of the offense. How recently the offense occurred. Any information the applicant provided in their favor. I ain't do it. If the offense happened again in the future, whether that would impact the safety of other tenants of the property. Let me see. Murder, aggravated sexual assault, kidnap. Yeah, I would say so. But that's not good enough. Whether the offense happened on or was connected to the property that the applicant had rented or leased in the past. So basically, you could consider this as a crime. You could consider this crime if that person convicted of that crime did the crime in your property. They served their time, they came out of jail, now they're coming back to your property to rent from you again. That's what that's about. Wow, aren't they making it hard to figure out who it is that you can deny renting to? So if the housing provider intends to consider those criminal records, according to the FCHA, after a conditional offer, they cannot accept an application fee before disclosing that fact to the applicant and offering the applicant an opportunity to provide evidence of inaccuracies in their criminal record or other evidences of rehabilitation or mitigating factors. Now, to make it easier for you, the landlord, or you as a real estate agent who's trying to filter out tenants for your landlord, they put together a model disclosure statement on the Department of Community Affairs website. Hold on a second. I actually typed in this link and I went to this link. And you know what it shows you? Well, let's go back to the previous slide. It shows you this, what's on the top. Not very helpful. And then if the housing provider withdraws a conditional offer based on criminal record, they must explain in writing their justification for doing so, which can be fulfilled using this model notice that'll help you out and guide you through that. And if you type this link in, you know what it's going to show you? This down here at the bottom. Not very helpful. Yeah, I guess they want you to just be like, you know what? I'm going to rent to anyone and everyone, regardless of what crimes they did in the past. Interesting. So if the housing provider utilizes a vendor, maybe you're going to say, you know what? How about I hire one of these companies to do the background checks for me? They know the laws. They'll be able to figure it out, right? Well, if you do that, they shall take reasonable steps to ensure that the vendor, outside person, or entity is conducting the criminal record check consistent with the requirements of the FCHA. And the housing provider will still be liable under the FCHA for relying on criminal history inquiry conducted by a vendor or outside person or entity that is conducting it in violation of the FCHA if it failed to take reasonable steps to ensure the compliance. The whole reason why I hired someone else is because I couldn't figure it out. So you're going to be holding me liable because I hired a vendor and then they didn't do things wrong because I couldn't figure out how to do it. I hired them because they're the experts in it. Ugh. So housing providers are prohibited from discriminating against those with criminal records. In other words, a criminal just became a protected class. Now, you can't discriminate against those with criminal records in any advertising, notices, or publications. They also can't require applicants to submit to drug or alcohol testing or to provide information from a treatment facility. I guess they brought that up because you hear people all the time saying, you know, people collecting government benefits aren't supposed to be getting them if they are current drug abusers and stuff. But if they're in treatment, they can get those benefits, right? So the same thing applies with renting, right? When you're renting, we can deny people who are current drug abusers or pose a threat to the health or safety of others. But if they're in drug treatment programs, right, they're a protected class under the disability requirement. So that's why they put that sentence in there that you can't require somebody to go through this submit to drug or alcohol testing or provide information that they are actually getting treatment. You could only ask them if they're getting treatment. They'll be like, yeah, I'm getting treatment. And now they're a protected class. Okay, so now penalties. If you violate the FCHA, you may be subject to fines up to $1,000 for a first offense, $5,000 for a second, and $10,000 for more violations. And now the owner needs to sign and date, and so does you, the real estate agent. Wait, there was something that I was looking for that we didn't even. Did I skim over something there? Oh, I did. Wait. No, I read this. I'll read the whole first bullet point. There's something really interesting on this under the federal the Fair Chance in Housing Act. Check this out. Housing providers are prohibited from asking about applicants' criminal records until after they made a conditional housing offer, except for convictions of drug-related criminal activity for the manufacture or production of methamphetamine on the premises of a federally assisted housing. What does that mean? That means that if you were renting to somebody and they had a meth lab in the apartment you were renting to them, and they got busted for that. And they went to jail for that. They get out. Another landlord cannot use that as a reason not to rent to them because they had a meth lab in somebody's house. But if they were renting in a federally assisted housing, basically government rental housing, and they got busted for having a meth lab there, well, now you could use it against them. That doesn't seem right. Seems like the government's carving out exceptions for themselves. Politicians never do that, do they? All right. I just like to point out the little things that often like go over our heads that we didn't even pay attention to, you know? Anyway. Other provisions. Okay, we already went over that stuff. Multiple dwellings. Yeah, you know, if there's an apartment building that has 25 rental units, you know that the owner or property manager is required to put together a report and submit it to the state every year. What the racial composition of all the tenants are. They submit that to the state. I don't know how they do that, especially when we're in such a. It's not like we're in the 60s anymore. We got mixed society here. You know, we got people from different races that are marrying and breeding with each other. So what are we going to call them? Are you Hispanic? Are you white? Are you black? Are you mixed? And then what do we call them? You know, so how exactly are they putting together these racial composition reports that they're submitting to the state? Do you live in an apartment building or facility that has 25 or more rental units? Do you know that your landlord has been submitting these racial composition reports to the state? Wonder how they were putting them together. Now, the purpose is to monitor possible discrimination if no minorities live there. Okay, I understand the reasoning behind it, but today, I don't know how you put this report together unless you actually ask the tenant, what race are you? What race are you? What race are you? How else would you know? You know? Can't tell just by looking at people. All right. We already went over this one, the buyer's love letters, in another chapter, so I'll kind of skip over that one right now. Remember the one where you can't write the buyer's love letters trying to convince an owner to accept your client's offer, your buyer's offer, because of this letter that they wrote trying to convince them to accept the offer, because it could include pictures or mentions of what their background is, their race, their religion, or what have you. So therefore, it could introduce some sort of a bias, and therefore making landlords fearful of accepting your offer over someone else's because they could be claimed of discriminating. That's what that one was about. You know, remember this guy?
Lee, Senior Counsel and Director of Legal Affairs at NAR.
So we went over this one already, so we could kind of skip over that one again right now. We don't have to go over that again. Instead, I'd like to spend more time on this. Mount Laurel. Anybody hear this? I actually heard something about it recently in the news. Where was it? Oh, no, it was on Facebook. There's a farm in New Jersey. There is in Cranberry. Anybody hear about this one yet? In Cranberry, New Jersey, there's the state's trying to take a farmer's property away so that they could build housing. Anybody hear the story yet? The reason why the state is using that excuse is they're saying under the mountain court decisions, we're required to create so much income and affordable housing. So that's why we need to take his property by eminent domain if he doesn't agree to sell it to us. So you got this farmer who's got a farm, and they want to take away his farm so that they could build housing there. My question, my argument is using the powers of eminent domain that the government has to take someone's property if it's needed for a greater public good with just compensation. My argument as the property owner would be, why do you need my property? There's a lot of land around here. You could take a warehouse or take someone's warehouse or one of these businesses, other businesses. Why do you need my property for that? You know, and that's a good argument to make in court. There's a lot of vacant land around here. Why are you using mine? Because I already have utilities to it? Because I'm close and I'm better located? That's not a reason. That's not a reason to take my property. So anyway, before we get into that any further, zoning discrimination, Mount Laurel 1 and 2, you'll absolutely get questions on this on exams. Mount Laurel is a municipality here in New Jersey. And in 1971, a lawsuit came about that came to be known as the Mount Laurel 1 court decision. It was filed by the NAACP against the town of Mount Laurel, New Jersey, for the illegal discrimination against low-income and moderate-income persons through the use of something that came to be known as exclusionary zoning. All right. It didn't really have so much to do with moderate income. It had to deal more with low income and affordable housing. They always lump in moderate income because it's the biggest segment of people, and they want to get the biggest segment of people mad when it comes to lawsuits and stuff. So the court stated that all developing communities had to zone for their fair share of the regional need for low-income and moderate-income families. So in 1975, the court ruled that the poor may not be excluded from residential areas. All right, so let's take a recap. Let's take this all in. What actually happened? Because they don't tell us a lot of detail here. So me as an instructor, I did my research in order to teach these classes. So what happened in Mount Laurel in 1971? What was going on there? This makes it sound like this town of Mount Laurel was a bunch of bad, mean, rich people that hate poor people, and they want to bring them. Is that the impression you're getting from what we read right now so far? You know, so what actually happened in Mount Laurel back then? Well, let's first get a little history lesson. You guys ever hear of something growing up in school, in your history classes? You guys ever remember something called the Underground Railroad? That was a route for slaves escaping from the south, escaping up to the north where they could be free. They were smuggled up by white people that were sympathetic to their plight. They smuggled them up north, so that risking their lives so that they could come up here and be free. Well, one of the end routes of the Underground Railroad was right here in New Jersey. It was in Mount Laurel. So over the years, we had a huge population of people that they came, well, back then with the slave, the former slaves, they're now free. A lot of them settled in Mount Laurel. A lot of them moved to other places throughout the country. But those that settled way back then in the 1800s, the early 1800s, what they did is they didn't have building and zoning ordinances and building codes and things of that nature. You built a house, you chopped down some trees, and you built a house, right? So they built a lot of houses close to each other. And so even to this day, even though those homes have been modernized, there's a lot of homes that are built very close to each other on small lots. Okay. The town of Mount Laurel, New Jersey said, you know what? We want to modernize our infrastructure. We want to improve our roads, our school system, police, fire, our city services. Where do your municipalities get the money to do this? Anybody know? Where does your municipality get the money to improve the roads, to deal with the schools, the infrastructure?
Taxes.
Okay.
Taxes. Property taxes. That's where they get the money from, your property taxes. Now, what determines how much they could charge you in property taxes? Anybody know that?
Income?
No. Your property taxes we're talking about. What determines how much your municipality can charge you for your property taxes? It is not based on income. It's based on the value of the property. Now, there's a lot of contributing factors that determine the value of the property, the size of it, how old it is, all of its features and things of that nature. It's based on the value. So you got a lot of these little old homes built on top of each other. The municipality is limited in how much they can raise their taxes and how much they can charge them, right? So the municipality came up with a bright idea. Any new construction that's going to happen in the municipality has to be done on a bigger lot. Now, people will build bigger homes. Those bigger homes will be worth more. We could charge more in taxes. Makes sense? Yeah. Sounds like a good plan. However, it was poorly executed because they overdid it. They required an overly large size lot. Now, I wasn't able to find out what size that was back then, but for the explanation here, just to prove our points, let's make up an overly large size lot. Let's just say it's an acre, right? That the town of Mount Laurel, New Jersey required people to buy at least an acre of land to build a house on. So people who couldn't, land is expensive here in New Jersey. Having a whole acre of land is, you got, who's gonna build on that? You're gonna have people building mansions and McMansions and rich homes. Well, that's good. It's gonna generate a lot of tax revenue, right? Good idea. Hold up. If you do that, aren't you pricing poor people out of the town that may have wanted to move in and build a house? They may not be able to afford a whole acre of land. So aren't you pricing poor people out? Aren't you discriminating against the poor by doing this? Yeah. So essentially that's what happened. Mount Laurel, New Jersey required too large of a lot size. And then the argument came with this court suit that, hey, you're discriminating against poor people by requiring such a large lot size. Poor people can't afford to move into this town, so you're pricing them out of the town. So the courts agreed that, even though the town had a good idea, they poorly executed it. They should have had a range of lot sizes throughout town, but instead they just had one large lot size requirement of an acre throughout the whole town, effectively pricing poor people out. So court decision, good decision. The town had a good idea, they poorly implemented it. Let's just not assume that the town is racist. They had a good idea, they poorly implemented it, and they required that overly large lot size. So as a result, the court stated that all developing communities had to zone for their fair share of the regional need for low income and moderate income families as well. So a range of lot sizes now. Now, in 1975, the court ruled that the poor may not be excluded from residential areas. I guess saying that you can't have those smaller lot sizes over by the commercial properties, in the bad areas that are not so desirable. Now, in 1983, a second lawsuit came about. The second lawsuit by NAACP against Mount Laurel resulted in the courts providing specific guidelines for developing communities. I don't like the way that's worded because it's inaccurate. The courts did not, I repeat, the courts did not provide specific guidelines for developing communities. The courts required that local communities create their own specific guidelines on how they were going to achieve the goals of providing that region's fair share of housing for low income and affordable housing. So they required those municipalities to create their own rules on how they were going to implement this. And more than half of them never did that. Why? Because there were no consequences put in place if they didn't. That's why. So let me see. If a judge tells you you need to come up with a bunch of laws that you're going to need to abide by, and if you don't abide by them, then you could get in trouble. Are you going to create a bunch of laws? Hell no. Common sense, no. So none of these municipalities did, or more than half of them didn't. So that's actually what that first sentence, or part of the sentence, spoke about. And it also said that municipalities have an obligation to provide a range of housing. And this was accomplished by allowing for higher density developments, meaning building homes closer together than normally allowed. A 20% set aside. What's a set aside? Okay, let's just assume that means for every 100 homes built, 20% of them, 20 of them need to be for low income and affordable housing. And zoning for mobile homes, and the requirement that communities must cooperate with efforts to obtain subsidies. That's money. The municipalities have to try to get money, apply for money from the state and federal government. Subsidies, a dirty, dirty word. So a panel of 3 judges appointed by the Chief Justice was set up to handle similar cases. Okay, so people who were negatively impacted by municipalities, local zoning laws, if they feel like they were negatively impacted and that municipality never created those specific guidelines that the Mountain Law Court decision required them to create, they could go and plead their case to this panel of 3 judges. And then the panel of judges can say, municipalities not allowing you to build what there? Okay. Did they create those specific guidelines? No, they did not. No. So what we're going to do is we're going to bang our gavel and we're going to say, you could build whatever the hell you like. You could ignore your municipality's zoning laws. That's what it does. It's a loophole actually created in the law. Because several years ago, Governor Christie, just before he was done with his term as governor, he started trying to run for president. You guys remember that? There were 2 weeks that he was in the news and all the headlines for 2 weeks. Because he went to he was still the governor of the state, still had the obligation of running the state. So he went to all the, plus he was trying to get brownie points, I guess, to try to run for president. So he went to all the politicians in New Jersey, you know, Republicans, Democrats, Independents, and he said, listen, guys, these Mountain Law Court decisions, they're not doing what they were intended to do. We're not getting all this low income and affordable housing built. So we need to just scrap these laws and write new laws from scratch because they're full of loopholes. We need to write a new law from scratch without all the loopholes in it so that we could get this housing built. Now, Governor Christie being a Republican, a lot of the politicians in New Jersey being Democrats, there was a presidential year, politics get involved. All you heard for the next 2 weeks in the media, in the Star Ledger, on TV, all you heard for the next 2 weeks was Governor Christie proposes racist legislation to do away with long-term protections for minorities, income people. That's all you heard for like the next 2 weeks. So he saw that the politicians were not going to do it, that they chose to just attack him on that anyway and spin this story to, he proposes to do away with protections for low income and minority people. So he just threw up his hands in the air and said, okay, I give up. I see this is not going nowhere. I give up. I give up. I give up. So nothing has happened with these laws. No changes, no trying to fix the loopholes, no nothing. So as of now, it's still the law in New Jersey. And it's full of these loopholes. And this loophole where I told you that if somebody wants to build and that municipality did not create the specific guidelines, and your municipality's zoning laws don't allow you to build whatever it is you want to build, you could sue the municipality and take it before this panel of 3 judges in what is called builder's remedy. That's the name of the lawsuit, Builders Remedy. You're suing the municipality, asking them if you could ignore the local zoning ordinances so that you could build whatever the hell you want, in a nutshell. Now, the purpose of this is supposed to be to build low-income and affordable housing, but in put into practice, you could build whatever the hell you want when the judges tell you that you could ignore the zoning laws. It's just that they use. So, anybody here know the town Cranford? Anybody ever hear of Cranford? This is only one of the towns that I could bring up off the top of my head. You know the train station in Cranford? Right across the street from the train station in Cranford, those blocks were all single-family houses for blocks and blocks and blocks. A developer bought those blocks of houses, and then they wanted to tear them all down, put in storefronts with high-end luxury condos above them. The town said, you can't build that there. It's not zoned for that. So the developer went and sued. They found out that the municipality did not have that specific guidelines for builders, the specific guidelines that the Mount Laurel court decisions required. So then they got the, and guess what's there now? Storefronts with that housing above it. And I don't think that there's any low-income housing there. I think that stuff is all actually pretty pricey. And how did they do it? Builders Remedy. Don't believe me? Do a Google search. Search for the Cranford Builders Remedy, or search just New Jersey Builders Remedy, and you guys will find tons and tons of lawsuits where this is happening. And what ends up getting built is not the low-income housing. It doesn't get built. So Governor Christie was right when he said that these laws are full of loopholes for developers just to build whatever they want, but that low-income and affordable housing is not getting built. This is the unfortunate part of politics getting involved in here. Politics is a dirty game. You got Republicans, you got Democrats, and they don't communicate anymore. They just knock each other, and they don't accomplish anything to satisfy the needs that are needed for the low income and affordable housing. So that lawsuit's called Builders Remedy. You don't need to know it for your exams, but you'll find it useful maybe in your life if you're dealing with builders, or maybe you have a project you want to do and it's in one of these towns that didn't put together those specific guidelines. Now, what do we call that practice? This is what we need to know for exams. This is all we need to know. I told you this whole long story to teach you a little bit about real estate and the lawsuits and how you could ignore local zoning laws, or you could get your clients to, if you have clients that were planning a project like that. What you need to know for exams, though, is just this. Exclusionary zoning is a discriminatory zoning practice that was outlawed by the Mount Laurel court decisions, which discriminated against low-income persons, the poor. Boom, that's all you need to know. What is a discriminatory zoning practice outlawed by the Mount Laurel court decisions? Exclusionary zoning. Or maybe they could ask it a different way. Maybe they could say, exclusionary zoning is a discriminatory practice that discriminated against low-income persons, which was outlawed by the Mount Laurel court decisions. Okay? So that's what you guys need to know for exam. They could ask it a couple of different ways, as long as you understand that. But I'm telling you, it's absolutely, without a doubt, going to be on exam. Okay, so there you go. If you want to you want to snap a picture of just that on a slide, there you go. And I have the roll right up here about builder's remedy. All right. You got that screenshot? That's great. If not, let me know if you need another second. Otherwise, I'm changing the slide. Equal code for equal opportunity. We have standards of conduct that realtors have adopted with an affirmative pledge to offer equal service to all persons that come to us for housing. HUD and NAR have also had partnership programs founded on the principle of focusing on and achieving fair housing through local community initiatives and training and educational programs. We have to display that poster from HUD as well as New Jersey for equal housing opportunity. We have to prominently display that sign, a display of a sign stating that discrimination is against our company policy. We have to make proper responses when clients express discriminatory desires to us. We're also going to learn that reverse discrimination is a thing. I know some people say, there's no such thing as reverse discrimination. You can't discriminate against white people. Sure you can. That's a racist statement all in itself. And advertising, we're going to go over advertising rules, what you can and cannot say in an ad. So let's highlight this on page 86. The laws are clear and widely known. The complainant does not have to prove guilty knowledge or specific intent, only the fact that discrimination occurred in order to be found guilty of discrimination. And if we go down here, what do you say to somebody if they tell you they're looking for housing and they're expressing a discriminatory desire? So basically, if a prospect expresses a locational preference, I'm looking for a house, but I don't want to be by these people or those people or whatever. How are you going to respond to that if somebody were to be so bold and say that outright to you? In all my years in real estate, I had one guy ever say that. This is what you would do. You would say, now, this is the advice that they give. It's a little bit robotic. I try to come up with a way that you could just talk to people like a normal human being. You know, here they give a little robotic response. I cannot give you that kind of advice. I will show you several homes that meet your specifications, and you will have to decide which ones you want. You sound like a friggin' robot, right? Listen, if somebody tells me they're looking for a house, but they don't want to be by these people or those people, my response to them is going to be, well, what exactly is that? New Jersey's a melting pot. We got people from all over the world living here. I was like, you picked the wrong state to move to if you don't want to be living by these people or those people. You know, you need to be out in the sticks somewhere where there's nobody living, you know, if that's what you want. Plus, I can't enter this conversation with you. I can't even entertain it with you. You know, it's discriminatory. It's illegal. I can lose my license for it. I can help you search for a home based on the criteria of the home itself. You tell me what town or what section of town you want to be in, what your price range is, what the features are for the house, and I can help you find a house. Okay. But if you start telling me that you don't want to be by these people or those people, I can't search for homes for you based on that. Okay. I don't even want to hear it. And I've said that to people, and I've done pretty good. Okay. So you guys could either choose this robotic response or you could do it the other way. Now, even with that, I've had listings where I've had people call up. I remember this one particular listing. I'll give you an example. I had people calling up, many people calling up over this property in, it wasn't New Brunswick. I think it was East Brunswick. It was a townhouse. And I had a lot of people calling on this one unit. And one of the common questions that I was getting was one that I didn't normally get. People were always asking, who lives there? Who lives there? I normally never got that question when I'm selling a house. Who lives there? They asked me about the house. you know? But I kept getting people to ask me who lives there. I was like, well, the owner lives there, but don't worry, she's moving out. You'll get it vacant. It'll be delivered vacant. And they're like, no. Who lives in the area? Who lives in the community over there? People. I'm sure they're very nice. Well, no. What kind of people? I'm like, ma'am or sir, you know, I can't talk to you about these types of things. It is considered discriminatory. I could lose my license. I said, if you're interested in the property, let's set up an appointment. You could come down. I'll show you the unit. And then you could go walk the neighborhood, talk to the neighbors, and see if it's a place that you would like to live in. Okay. And I left it at that. And I remember I had one lady, she called up with a strong New York accent. And she asked me the same question, you know, who lives there? And I was like, ma'am, I can't talk to you about that. I was like, I could show you the place and then you could walk the neighborhood. And she's like, no, you got me all wrong. Me and my husband are Yorkers, a diverse neighborhood. So who lives there? Oh my God. It doesn't matter your reasoning behind it. You're still asking me the same question. I cannot discuss that. I cannot engage in that conversation with you. I could lose my license for that. I could get fined heavily for that. I could talk to you about the house, the features of the community even, but I can't talk to you about the people that live in the area. Okay? So you guys got to be prepared for that kind of a question if somebody ever asks it to you. You never know who's on the other end of the line. It could be somebody called a tester. Tester are undercover mystery shoppers that are trained by HUD, the Department of Housing and Urban Development, on how to test real estate agents to see if they're treating everybody fairly and equally, or if they're engaging in discriminatory conversations and banter and behavior. Okay? Everybody got these? All right. So reverse discrimination is a thing. So let's highlight that on page 86. In recent years, brokers have sometimes been caught in the middle when local governments enact well-meaning quotas. When talking about race and using the word quota in the same sentence, it ain't good. But it gives rise to something that's known as reverse discrimination regulations. Now, they're intended to preserve racial balance in given areas. And the book goes on and on and on. I don't care what the intent is, because if we look at the very next paragraph, where is it? Here, this is page 86.
The first paragraph.
Yeah, this is actually on, let's see, reverse discrimination is actually towards the, a little bit below the middle of the page, and this is actually at the top of the page. So look at this. It does not have to prove guilty knowledge or specific intent, only the fact that discrimination occurred. So them trying to excuse the reverse discrimination, oh, it's meant to preserve racial balance in a given area. Yeah, politicians give that excuse all the time. And then there's lawsuits that come about. People are denied jobs. Look, you got plenty of police and firemen in New York City that were denied promotions so that they could give them to minorities who didn't have as much experience or haven't been on the job as long, because they were trying to preserve racial balance in a given area. Okay, today we call that DEI, you know, what is it, diversity, equity, inclusion. They come up with different names for it, you know. DEI, I think it stands for didn't earn it. You know, if you've been on the job long enough, doesn't matter what your race is, you will be in that position for that promotion. But when you start giving people a leg up, look, years ago, I applied to be, I took the civil service test, and I was going to apply to be a police officer. And I scored pretty high on the tests. But at the time, we had a lot of people coming back I think it was Afghanistan at the time. We had a lot of people coming back from Desert Storm, and we had a lot of veterans that got extra points because they were veterans. And then if you were a minority, if you were a minority of you get extra points added to your test. So I had all these people jumping ahead of me, and I never got a job there, even though I was like so close. I was like next on the list, and then I got bumped down. Next thing I know, I'm like 30th on the list again. So for a job, so I was like, yeah, you know what? I better find something else to do for a career. So it does negatively affect people, and essentially it is reverse discrimination. All right. All discrimination is wrong. So let's see. Here are some advertising rules. Instead of reading it in the book, we're just going to go by the chart that they have here. The advertising rules on what you can say and what you cannot say in your ads. Print ads, television, radio. This is not censoring your speech and how you could talk to people. This is talking about in your advertisements what you can and cannot say. So we got a category, a rule, what's allowed and what's not allowed. When it comes to race or color or national origin, the general rule is the same actually for all these categories. No discriminatory preference or limitation can be expressed. You are allowed to use the term master bedroom or good neighborhood. These are not considered racial terms. How racist do you got to be one of these people who's got race on your mind 24/7 if you consider the term master bedroom a racist. Yeah, I came back from the days of slavery where you had the master and he had the biggest bedroom and really? I mean, come on, you need to lighten up a little bit, move on with the times. Things have changed. Anybody know what a master bedroom actually is?
It's a main bedroom?
Yeah, but not all houses have a master bedroom, though. So I'm going to ask you to elaborate a little bit more to see, because I know like HGTV, all these fix this, fix that, and showing house programs. They say, oh, this must be the master bedroom because it's so big. It's the biggest bedroom, right? A lot of people assume that that's what a master bedroom is, but not all houses have a master bedroom. So does anybody else got another idea of what a master bedroom is?
If it has a walk-in closet.
Not necessarily a walk-in closet, but it can.
But
Is
by
it
the
for
way,
like family thing?
is it the biggest bedroom in the house?
It normally is the biggest bedroom in the house, but that alone does not make it a master bedroom. It has to have a bathroom in it.
Oh, I see.
If you that also has a bathroom in it, that is a master bedroom. Not all master bedrooms, not all big bedrooms have bathrooms in it. So not all houses have a master bedroom. Only those that have the bathroom attached to the bedroom are considered master bedrooms. And it is normally the biggest bedroom in the house. That is right, but it has to have that bathroom. Good neighborhood, that has nothing to do with race, color, or national origin. And what is not allowed, you're not allowed to say things in ads like white neighborhood or no French. Keep your ads positive, first of all. When it comes to religion, no discriminatory preference or desire. You're allowed to use terms in your ads that say chapel on premises or kosher meals available if there's a kitchen on the property. We're not talking about, hey, there's a store down there in the neighborhood somewhere that offers kosher meals. No. If you're like in a building that's a condo and they actually have like a kitchen that's there for anybody to get food and they serve kosher meals, you're just describing these features that are on the premises. Kosher meals available, there's a chapel on the premises. You're allowed to say Merry Christmas, Happy Kwanzaa, Happy Festivus for the non-religious folks, Happy this and that, you're happy, what are the other holidays? Anyway, you could say Merry Christmas, Kwanzaa, Festivus, what's the Jewish holiday? Around that. Hanukkah, Happy Hanukkah, you know. You could write all these things in ads, and it's not considered discriminatory. It's a greeting. Lighten up. You're not allowed to say things like no Muslims. First of all, no is negative. No Muslims. Nice Christian family or walking distance to synagogue, because these things could be considered dog whistles. You know, walking distance to synagogue. Hey, there's a lot of Jews in the area. Or it could be like you're targeting only Jewish people. It can be interpreted by different people in different ways. Instead, you should use more secular terms like walking distance to houses of worship. That's okay. But, you know, not walking distance to the mosque. That tells me there's Muslims there. Walking distance to a synagogue. That tells me there's Jews there. You know, I mean, you have to keep it more secular, you know, non-denominational, you know. When it comes to sex, no preference or limitation. You're allowed to use the terms in-law suite, mother and daughter, female roommate sought. And these are not considered discriminatory terms. Anybody know what an in-law suite or mother-daughter is? They both describe the same thing. It's a two-family house. I'm sorry, it's a one-family house that maybe has another apartment set up like a two-family, but it is zoned one family. These are often used by people. Let's just say you got a married couple, right? Young couple gets married and they want to keep their senior parent close to them. Their parent can get around on their own still, but you just want to have them not living. You don't want them all in your business living with you, but you don't want them too far away from you either. So it would be good if we found a house that has its own entrance and exit with its own kitchen, bathroom and stuff, so that they can live in that same house with you, you know. That would be a mother-daughter or in-law suite. It's a one-family house that's set up like a two-family. And female roommates sought. Why is that allowed? Isn't that sexual discrimination? No. A roommate is somebody who lives in the same apartment as you. You could have a young girl that says, I only feel comfortable with another woman living with me. I don't want this old guy creeper in here being like, oh, yeah, I'd like to move in with you, you know? So it is allowed to advertise that you're only seeking a female for your roommate, as your roommate. What's not permitted are great house for a man, wife's dream kitchen, man cave, or she shed. Now, these aren't things that you are not allowed to say. You're allowed to say these things. You're just not allowed to have them in your advertisements. Like if you're showing a house, you could be like, well, this would make a great kitchen. Now, I'm going to insult somebody and say, well, this is a great kitchen for the little missus, you know, for the wife, you know. I don't know about you guys, but the women in my family can't cook for crap. We actually, the guys are actually the better cooks here. So that's kind of a stereotype right there. You know, great house for a man. How about just great house? It's a great house. Dream kitchen. You don't have to assign it to a wife. Why? You got to be married? Why? It's only for women? You know? Anybody know what a man cave is? That became a popular term.
It's something like the man's favorite things in the room or some place.
And what is that usually? You know, a lot of times it's put in the basement, right?
Yeah.
You know, the guy takes over the basement. You know, he's got a room in the basement. He sets up a bar down there, or maybe like a movie theater with the nice leather couches and stuff, or maybe puts a pool table down there. You know, where him and his guy friends can go hang out, and when he gets away from the family, it's his home away from home, where he can hang out with his buddies and
They can make bar there.
Yeah, that's the man cave, right? Well, likely there's a similar thing like that. So in ads, you don't want to write that in an ad, man cave, because one of these hypersensitive people who are super offended by everything is going to end up trying to sue you over it. So you better, if you want to say something, you could actually say grotto. You know what a grotto is? In Italian, it means man cave. Or actually, it means cave-like room. A grotto is a cave-like room. But I didn't even say that. I just put the pictures in there and let the room speak for itself. When I'm showing the property, I could be like, wow, this would make a great man cave down here for you, huh? And we can have that small talk and conversation. But in an advertisement, I wouldn't put that there. Same thing with She Shed. This is another one of those Bravo HGTV things. And what was the insurance company? There was an insurance company that made a commercial about this. I'll show it to you right now. You guys ever see this one?
Well, it finally happened, Zachary. Somebody burned down my she shed.
Nobody burned down your she shed, Cheryl.
Well, my she shed's on fire.
Your she shed was struck by lightning.
Zachary, is my she shed covered by State Farm?
Your she shed's covered, Cheryl.
You hear that, Victor? I'm getting a new she shed.
Look at that she shed. She got chandelier in there. She got all kinds of decorations on the wall. Look at that get up. So like the man has his man cave in the basement where he got his pool table or whatever set up there, his movie theater. She could have a shed that's all customized with her chandelier. They got electricity, heat, and all that stuff where she meets with her girlfriends and gets away from the family. That's her getaway. The she shed that was sold as the opposition to the man cave. You got the she shed. Look at that. That's something.
She's here.
Well, it finally.
Just don't write she shed in your ads. And when it comes to disability, no discriminatory preference or desire. You're allowed to use terms like wheelchair ramp, walk to shops, walk-in closet, jogging path, or walking distance to something. And you're not discriminating against those who can't walk. A wheelchair ramp, walk-in shops, walk to shops means that they're close by. A walk-in closet, it means it's a pretty big closet if you could actually walk into it. It's a descriptor, that's all it is. Jogging path, that's not meant to discriminate against those who can't walk. You're not allowed to put in ads things like no wheelchairs or able-bodied tenants only. And why would you? That's kind of weird. Negative, it's negative too. Don't put negative things in your ads. Look, I had a listing. I had a bunch of listings in this place, but I had one particular listing here. It was on the 3rd floor at the Waterford in Edison, if anybody's familiar with. It's a condo complex, and it was a 3rd-story unit. And the only way to get up there is there's a winding staircase to get up to the top unit. So I called it a 3rd-story walk-up. And I actually had a guy call up about my ad, and he was asking me, is there an elevator in the building, or is there a possibility to put in a ramp? Because I use a wheelchair. I don't walk. I could walk. I could get out of the wheelchair and I could walk up a step or two, but I'm really limited. I can't really walk. I'm bound to the wheelchair. I was like, no, not really, because it's a winding staircase. There's no real way to put a ramp up there for you. And no, unfortunately, there's no elevator there in the building to get up to the 3rd floor. So I told him, I was like, but if you'd like, I could take a look and see if there's any units available on the 1st floor. And so this way, he still called up because I didn't turn him away by saying no wheelchairs or able-bodied tenants only. He still called up. I turned the guy into a client, just had to find him something that was on the 1st floor. That's the better way the better approach to do it. Don't chase people away that could potentially be clients. When it comes to familial status, no preference or limitation on family size or the type of family. You're allowed to say 2-bedroom, family room, or quiet neighborhood. These are just descriptions. You're not allowed to say things like married couples only, no more than 2 children. This is a retiree's dream house, or no young children allowed. These are discriminatory things. They're negative too. Keep your ads positive. I don't even like putting for sale sign, the sold sign writers on for sale signs because I think they're negative. we could still have people calling up on it, and I could still turn them into potential buyers of mine, right? You don't want to chase people away. Keep your ads positive. Okay, things here, testers. These are undercover volunteers, kind of like mystery shoppers that test us, real estate licensees. They pretend to be buyers and renters to ensure that all people are being treated equally, the same, and you're not engaging in any discriminatory practices or rhetoric. Now, they're not employed by HUD, because if they were employed by HUD, that would be entrapment. They are trained by HUD. These are volunteers. They're not paid. So they could be the same sex or gender, race, sexual orientation as you, from the same nationality, religion, or the opposite. This is why it works. You never know with whom you're dealing with. So you get a buyer, you get somebody that calls up, they're a buyer or a renter, they start asking you all kinds of questions that seem kind of out there. Don't fall for it, guys. Do not fall for it, because look, some people can just talk like that normally. Other people are just testers. They're trying to get you, they're trying to bait you into getting involved in a conversation to talk about something that is discriminatory. Don't do it. I've even met with a client that acted that way. And I was looking at her, I was giving her a name. Listen, here, let's do this highlight about testers while I explain it to you. I had this one lady, she called me up. She was like, she wanted to see one of my listings. And she said, she got there before me. And I got there, she already walked around the backyard. She said that she loved the property. This property's perfect size. She loves it. The house looks cute on the outside. And I took her, I showed her the inside of the house. She loved the house. Loved it. Now we get out and I'm locking up, putting the lockbox on, and she starts talking to me as I'm putting the key back in the lockbox and putting it up there. And she's like, you know what? I love the house. I love the property. She's like, but when I came, I had to come off the parkway and I came around this way and I had to drive by, these fried chicken places, and I drove through a neighborhood that was full of black people. She's like, I don't want to be in the ghetto. I don't want to drive through these places where there's all these fried food joints and black people. This is ridiculous, And I'm just like leaning now on the banister on the front porch, and she's leaning on the other one, and I'm just like, looking at her. No emotional response from me at all. I'm just like kind of like bouncing back and forth on the banister, the railing, and I'm like, okay. She's like throwing out all kinds of racist tropes that you could possibly come across against black people. And the weird thing is she's black. So I was like looking at her, I'm like, she's got to be a tester. This lady's got to be a tester, And so I'm like, I don't know how to respond to her. So I'm just like staring at her, what do you say? So it actually ended up, I ended up working with her, actually. She was not a tester. She was actually a legitimate client. She just didn't know. I don't know if she realized how things were coming out of her mouth and how they sounded. They sounded so racist against black people, yet she was a black person, so it came out so weird to me. But I ended up talking to her more, and I found out her situation, and she just wasn't mentally all there at the time, because both of her parents just died in a car accident, and she became the instant parent for her two younger twin sisters. All of a sudden, she's burdened with the responsibility. She couldn't afford the house that they were living in before to keep up on paying the taxes and the mortgage and all that stuff on it. So they had to sell the house, and then she had to she had to find another house that she could afford that was in her price range, you know. But when she was talking to me, I guess stress and everything was coming out so twisted. She wanted she wanted a house that was in a neighborhood similar to where they were at before, which was basically a mixed neighborhood, you know, white people, black people, people from all surroundings, and it was a little bit more of a money area, you know, because her parents did make good money, but unfortunately, they did not have the house paid off and all that, so she wouldn't be able to afford it. So I ended up finding her something really nice in her price range. Even got invited to the housewarming party, you know. But you guys are getting that's another bonus for getting involved in real estate. You get invited to some of the parties. But yeah, she ended up being a very nice girl, you know. But stuff just came out all twisted out of her mouth, you know. So be careful about chiming in on things that people say. And in this case, I thought she was a tester. You need to know what a tester is for exams. They're like those undercover mystery shoppers. And that concludes chapter 4. Jeez, I figured I'd be done with 5 by now. All right, so tomorrow we're going to hustle through this stuff. Oh, shoot. Tomorrow we're not going to hustle through this. You're going to be hustling through this with Meritus. Let me stop the recording.